Sam. Kick off. This is Wellington Proposed District Plan Stream 3 hearing. Those who haven't been involved or listening, my name's Trevor Robinson. I'm chair of this hearing, accompanied by Commissioners Lutz, Faulkner and McMahon. Any preliminary procedural issues?
Nope.
Well, in that case, we'll commence with the council case. Mr. Wellington, do you want to tell us what the plan of action is?
Certainly. So the proposed plan of action, subject to your having a different view, is that I will start by giving some submissions about the Waikanae Land Company case and a couple of other rats and mice type issues before handing it over to the real stars of the show to give their evidence and to be questioned by you.
Right.
I don't propose to take too long. I suppose it depends on how many questions you have for me about the case. What I propose to do is talk about it in reasonably general terms, but if you've read my submissions, I don't need to spend too long doing that. I can simply talk about it in general terms and have your questions about it.
That's fine. As you say, we've read your submissions, read the case, about it a little. Commissioners McMahon and I had already seen the Pairua legal submissions that you provided us with through our involvement in that process. So over to you.
Thank you. Well, that's a good place to start. I provided those submissions for a couple of reasons. One is that it's never particularly appetizing turning up in a tribunal or before a panel and seeking to argue that a decision of a court is wrong. But in this case, there is at least a reasonable degree of congruity among other lawyers and other counsels that something may have gone wrong in that case. One of those counsels, obviously, Kapiti Coast, you can expect to be a little biased because it involves them. But I take some comfort from the fact that Porirua City Council submissions have separately and independently reached that same conclusion that I have about the case. Another interesting point about it, which I didn't put in the submissions, is that the relief that the judge gives is a little strange. Because as I read the reasoning of the court, it's mainly the issue, the unlawfulness is mainly because of the rules that the Kapiti Coast District Council put in place to protect the urupa, involving things like fencing and earthworks provisions, changing the activity statuses of those sorts of activities. In addition to the changes it made to the height and densities that would be otherwise allowed. And it seemed to me that there's a reasonable case, if that was the reasoning, that the relief should delete those parts of the plan or uncouple those parts of the plan from the listing in the schedule, the appendix, rather than declaring or concluding that the entire listing of the urupa was unlawful. But it obviously is relevant for our situation for a number of reasons. Most notably, that as I read it, the corollary of the decision is that a council cannot list new heritage matters or new natural hazards, in anything new effectively, which seeks to manage a resource management issue by way of affecting how the MDRS or Policy 3 would otherwise be given effect to through the plan, is something that the court says should be going through the Schedule 1 process. And you've heard that in hearing stream 1 from a number of submitters, Dr. Keir and Ms. Cutton, for example, and those submitters who say that it's more appropriate for new listings to be going through Schedule 1 so that they have Environment Court appeals available. So that's why I see the case as relevant.
Is the issue that they were arguing that they were new, or that that they were affecting the MDRS, or more that it would have affected the plan equally without the MDRS?
Well, it's a little difficult to tell exactly what the issue was, because the court's reasoning is not so much that it's new, although I think that's a corollary of what the court decides, but it was squarely put by the applicant on the basis that it was because it was a new listing. And I just thought I would find that, because the way it was put in the memorandum of counsel, which raised the issue and which is then quoted in the decision, is that the new Wāhi Tapu listing ostensibly protects historic heritage and therefore has immediate legal effect for the purposes of the consent application. It doesn't change the activity status, but it triggers the application of additional policies that relate to protection of historic heritage.
Because, like, the argument seemed to be, well, it's the same argument that Dr. Keir made to us at the start of stream 1, that it's not it's not supporting or consequential on, because it affects, it's not focused on the difference the MDRS makes.
That's exactly right. And so then it goes on to say WLC will contend that the new Wāhi Tapu listing cannot be introduced under an IPI.
Yes.
That's the way it was put by the applicant, and that's very similar to the way Dr. Keir and other submitters put it in hearing stream 1. My answer to you in that hearing stream 1 was to go back to section 80E1A and point out the reference in that provision to policy 4 of the NPSUD, and that's effectively the same argument that I've made in my written submissions, that when you are providing in the IPI for rules, for provisions that amount to creating the rule framework, whether it's a zone, whether it's a rule framework, whether it's an appendix or a schedule with a listing, however you give effect to that policy 4 by making the MDRS, if it would otherwise apply, or policy 3 if it would otherwise apply, less enabling, then that is happening through the mandatory category, through that 80E1A part of the definition of the scope of an IPI.
Trevor, can I come in there?
The question that immediately occurs to me is, you drew us in stream 1, you drew a distinction between provisions that directly affect the MDRS or policy 3, like heritage, and things like 3 waters that are indirectly affected. Given the emphasis on policy 4 making less enabling, what does that say for those indirect effects? Don't they make the MDRS less enabling because they are subject to for instance, a 3 waters condition?
Yes, I think that's right. Or to put another way, I see the argument that I'm making now as consistent with that. And the way I've put it in my written submissions is at paragraph 2.24, and this is a passage that links back to the earlier submissions that I made in that hearing stream, which is that you have the provisions that are directly making the MDRS less enabling. So, for example, a rule that instead of providing for an 11-metre height limit provides for something less, or a rule which says that an 11-metre height limit is fine but restricted discretionary instead of permitted. That sort of thing is directly impacting on the application of the MDRS. It is giving effect to policy 4. It is mandatory to do that through the IPI. So something like the Three Waters chapter does not directly do it. What it does, though, is support or be consequential on the
Well,
MDRS.
but you could equally saying it's making the MDRS less enabling because it's subjecting it to a condition that there must be adequate infrastructure. Isn't that make it, and that is a reason why something that would otherwise be permitted under the MDRS is not permitted, and in fact may not even be able to be consented.
Well, yes, and if that's right, then that provides an even stronger reason why all of those categories that the council decision on the 12th of May last year, where it considered those content pathways, where the officer report put those sorts of things in the discretionary category. If what you're really saying is that they are in the mandatory category, then that's all the more strong a reason for the argument that they must have been included in the IPI and cannot be included in Schedule 1.
And remind me, are the Three Waters provisions identified as IPI provisions?
I'm boned up on them in preparation.
Mr. McCutcheon.
McCutcheon will know.
Yes, they are.
And natural hazard must be in the same category.
Yes, they are.
An example might be the wind chapter. The wind chapter has been included in the IPI, ostensibly as part of the discretionary category, but I'll look to Mr. McCutcheon to explain why that is, to put him on the spot.
So in a similar way to the Three Waters provisions, the wind chapter imposes restrictions or requirements on the achievable heights and densities where there would be adverse wind effects that would create safety or comfort issues, especially within the city centre zone where there's supposed to be maximising development potential, as well as within the centre zones where policy 3D of the MPSUD is directing intensive building heights.
So I think that is saying in another way that it's not so much reducing the heights that would otherwise be available, but it's subjecting the resource consent for those heights to an additional consent requirement. So whether you call it less enabling is, I suppose, a matter of construction or interpretation. The approach that we were taking was that it is not necessarily changing the way policy 3 would be implemented. It's that the plan still provides for the level of height that it would, giving effect to policy 3 in its entirety, but it is nonetheless providing for an additional consent requirement, and in that way is both consequential on and supporting the policy 3 in that case.
Okay, sorry I interrupted you.
No, that's helpful. So standing back, I said I would address this in general terms, and standing back and looking at the case, to me the outcome itself is quite surprising, because without going into the detail of the provisions, the Act requires the incorporation of the MDRS in policy 3. It allows reduction to change the way that those provisions are given effect to for qualifying matters. There are two types of qualifying matters. that the Act refers to existing qualifying matters, and then by the other side of the coin, new qualifying matters that are not recognised in an operative plan. And the Act provides different evidence requirements for those two types of qualifying matters. And on that basis alone, it's a surprising outcome to find that you can't put new qualifying matters in the IPI. The entire structure of the Act suggests that you must be able to.
Another way to put it is the purpose of qualifying matters is to, as you say, make the MDRS or Policy 3 outcome less enabling. Therefore, it would seem inherently odd if the IPI rolls, it's immediately operative, and any qualification has to wait for a subsequent
Decision.
first schedule process.
Well, yes, or even a decision, but that's exactly right. I agree entirely with that, because you'll end up with a period where savvy onto it developers can effectively undermine the subsequent imposition of different planning frameworks through the qualifying matters if they're going through Schedule 1. Sort of defeat the entire purpose of the legislation. In fact, there is that that prospect is recognised in the Select Committee report, because, of course, one of the points raised by submitters on the bill was, well, what happens if the council fails to identify a qualifying matter? So, for example, the special character concerns were that if the council doesn't notify special character areas, and submitters seek to bring it in by establishing special character as a qualifying matter, there will have been a period of time where people in those areas have had the MDRS applicable and can undertake development as a permitted activity. And Parliament said that they accept that that's a prospect or possibility, but didn't want to change the bill to change that to affect that was a possibility.
Now, obviously, as you say, it's a bold statement to suggest that an Environment Court decision was wrong, at least until you've got a High Court judge to agree with you. Technically, say an Environment Court decision is not binding. What happens? Because you've told us that KCDC has appealed. What happens if a High Court judge does agree with Judge Dwyer? Is that binding?
Well, no, but I think it's significantly more persuasive. At the end of the day, it is a decision on particular provisions in the Kapiti Coast District Plan, which, as I say, are distinguishable from our situation. If a High Court judge agrees with Judge Dwyer and the Commissioner, then it'll be significantly more persuasive on the point. Well, it depends on the reasoning, of course, and that's why I raised the relief point, because even if you accept my point that the court can't be right if what it is saying is that you cannot have a new heritage listing or site of significance to Māori listing in an IPI, if that's what the court's saying, then in my submission it's wrong. You can still, I think, legitimately criticise the Kapiti Coast District Council plan for having fencing and earthworks rules that are changed through that process. I happen to think that they are related provisions. Judge Dwyer does not, but that's a matter of degree as to how closely they support or are consequential on the changes that are sought to be made. So while I disagree with the judge on that point, it's entirely possible that the High Court might say, well, the judge was wrong that you can't have a new listing, but the judge was right that fencing and earthworks rules should have been going through the Schedule 1 process. And that's why I raised the relief point, because to me, if that was the true reasoning, then the relief ought to have been quite different.
Now, next question about potential appeals. Do we have any idea what the time frame for a High Court decision is, particularly as it relates to our time frame?
Look, I don't, but I can make inquiries with you, and perhaps I'll do that over the morning break and see where I can get to. I can't promise that there'll be an indication, but I mean, look, if it was me, and it's subject to the court's leave, of course, but it's the situation where you might seek urgency from the High Court, given the significance of the case to the processes going on up and down the country.
Well, no doubt KCDC are in the same position that we're in.
Exactly.
And so they'll want a decision as soon as possible, because they've got their own IPI to determine.
That's right. At the same time, we're all aware of the delays in the court system as a backlog from COVID. I filed a proceeding yesterday and was told there's an 8-week processing delay. So there's a number of matters that the High Court will be worried about. So whether urgency can be afforded or not, I simply don't know.
You know, going back to your reasoning, saying, well, if provisions implementing qualifying matters are mandatory IPI matters because they make less why does ADE2 list qualifying matters as the other potentially related matters?
Because we bring ATE up. So ATE2 purports to provide not an exclusive definition, but an inclusive definition of related provisions. Now, there's been argument about whether all of those matters listed also need to support or be consequential on the MDRS, and a number of parties have suggested that it must do, and Judge Dwyer said that it must as well. I haven't taken that position, but equally I'm not suggesting that you need to decide it now. But the reason in my submission that there is this ATE2 is to make it clear that the types of things that may support or be consequential on the MDRS or policies 3, 4 and 5 may include district-wide matters. For example, overlays, any of the sorts of things that you would implement through an overlay framework, such as a heritage item, may be included as a related provision. Council has an election, has a discretion about whether it includes it or not. They can take one or either approaches. Same with earthworks, same with fencing. The fact that fencing is mentioned there is highly significant because, of course, how does fencing touch on heights and densities? How is it related to it? It can, as I suggest, Kapiti Coast District Council was determined, it helps to support the protection of a heritage item or an urupa or some qualifying thing that you're trying to protect. And then qualifying matters identified in accordance with 77I or 77O is simply to make clear that when it comes to qualifying matters, the council has a broad discretion as to how it goes about it. To the extent that it is directly giving effect to or changing the heights or densities that would otherwise apply. It's mandatory, but there may be other provisions that you impose which rely on a qualifying matter, which you decide are related.
But if
Alternatively, it could simply be OTIOS because a qualifying matter would go through the MDRS, go through ATE1, ATE1A.
because I was going to say that you've gone back to because it directly changes heights and densities, but your policy 4 argument suggests, well, I was thinking, well, the only rationale I could think of, like you're right, it might just be unnecessary, but the only scenario I could think of was one where you have a flood hazard, some of which applies in the urban area and is clearly a qualifying matter, and some of which applies in rural areas, but it doesn't make that distinction. It's a set of provisions, a set of maps.
Well, that's right, and actually, that's exactly how the council has dealt with a number of matters, where it's an integrated plan. So there is an integrated set of provisions. It doesn't have natural hazards provisions that apply only in the urban area and a separate part of the plan with similar provisions applying to rural areas. And so they're going through as one in the IPI, and there's criticism. I think it might be the Wellington Airport argument that the council has inappropriately included these district-wide matters in the IPI, which are applying to non-urban areas, and therefore, while wants to be able to challenge those in the Environment Court is what I assume they're saying, but it won't be able to. And the answer for that is because it's an integrated set of provisions relating to a qualifying matter, and to the extent that it applies in non-urban areas of the city, it fits within that.
Just shifting ground again, something I should have asked you previously. There are qualifying matters that council decided in its discretion shouldn't be part of the IPI. Does your reasoning suggest that those decisions were ultra vires?
I don't think so, because in none of those cases was it directly, arguably it's not a qualifying matter. They were, come back to what they were.
Can you give us an example so we can know clearly what we're talking about?
But the reasoning was that they weren't directly affecting heights and densities. So, for example, SNAs. The SNAs weren't, as the council ended up determining it, going to apply in residential areas. But you'll recall we had the discussion about how the rule framework was to work. All it does is affect vegetation clearance in residential areas. It doesn't affect whether you can get a resource consent or whether you have it as a permitted activity, whether you're able to build up to 11 metres, or whether you're allowed to put 3 dwellings on a particular property. And in the earlier hearing, I think your example was, what if 50% of the site is, or more than 50% of the site is covered in indigenous vegetation? Does that mean that it is effectively a qualifying matter because you need to clear it in order to be able to practically give effect to the permitted activities that the plan provides for? And that was a point that hadn't been considered. The reason that the council decided not to include it was that while vegetation clearance may support the application of the MDRS, it was something that the council, the application, the mapping, was something that the council wanted to go through the Schedule 1 process. But the distinction drawn was it doesn't directly affect whether whether the full extent of the MDRS or Policy 3 is imposed by the plan on any particular site. and therefore it's not within the mandatory category.
So let's just take the alternative hypothetical. Judge Dwyer is right. New heritage listings are ultra vires. Ultra vires the IPI process. Not there.
Well,
For this process.
I think you can ignore the new heritage listings, not make recommendations on them, and the council will have to go back and re-notify a Schedule 1 plan change or variation, I suppose it would be, to notify those listings as part of Schedule 1.
So it's not simply a matter of we're just treating them as non-IPI matters.
Well, practically that would be nice, but the argument we've already had is that in my submission you don't have that power, and I know that Mr. Winchester had gloss on that, but I'd have to reread. It's been a month or so since I last read his submission, so I would have to go back and check exactly what he said about that. But I don't think it's a matter of simply reallocating them to the Schedule 1 process.
Yes, I think if we accepted your argument that the council made a decision and we don't have the power to change it, then if the decision it made was ultra vires, then it's got to start again, got to notify them.
That's right. And it's consistent with other Environment Court case law about the freshwater provisions.
About the Otago litigation.
That's right.
I just had a couple of final points to ask you. Putting aside Waikanae and its implications, we have a number of submitters before us seeking new heritage listings, either heritage areas or heritage buildings or both. If we accept their submissions on their merits, is that an IPI recommendation or not?
Yes, it is.
And why?
Because what the submitters are asking you to do is apply a less enabling framework to that area or that property than the MDRS or Policy 3 would otherwise require, assuming it's in a centres or a residential area. And what they're asking you to do is to add a line or add a line to a schedule, or I suppose a hatching on a map, which map or which schedule is going through the IPI process already and has been notified as part of the IPI. So it's a submission on the IPI.
And it's a specific submitter, but it raises legal implications. Ms. Khan saying that the council's actions are discriminatory under the Human Rights Act. What's your response?
Well, is that a matter that's been raised before you?
Yes. It's in her submission.
Well, my submission is that it's not discriminatory.
Yes, but
I don't.
But is it a relevant issue? Like we have to make a finding on. Well, do we have to make a finding on the merits?
Well, the fact that it's been raised in the Human Rights Commission, I don't see as relevant. In other words, you don't need to defer to the Human Rights Commission. As to whether that means that you need to make factual findings about the basis on which the property was included in the plan, my answer to that's no, but I'm going to have to think about the reasoning a bit more, I think.
Yes.
We'll come back to that in the morning tea.
Yes, so suggest you do ponder that. And the other factual question, the point you're making, that 3.4 discussing Dr. Kerr and Ms. Carton's material they produced about compulsory acquisition. At 3.4, you say not to say that private impacts are not a matter to be considered in weighing them. Can you point us to any evidence that the costs Dr. Kerr and Ms. Carton have quantified flowing from the listing of their property have in fact been taken into account in a Section 32 sense?
Yes, I can. The point, so the question in general terms is, what is the impact of listing a heritage building? Now, the costs have been considered by Ms. Moira Smith, I should say, in her evidence, because of course we have Ms. Nina Smith, who has provided the valuation that Dr. Kerr and Ms. Carton rely on. And they've been addressed in her evidence at paragraph 65 and following. She relies on some literature, a number of studies that have been undertaken in the UK, Australia, and in Auckland on the impact of heritage listing, which find in general terms that it is not always a negative impact, and there is a general plus or minus 10% effect, basically.
But of course, Dr. Kerr and Ms. Carton have quantified it as significantly more than 10%.
That's right.
And so the question is, because this falls outside what you might call what Ms. Smith describes as the norm, has that been taken into account? And should it have been?
Well, I think it's a matter for you to take into account. At the end of the day, the test we're looking at here is 77J, and the costs and benefits need to be weighed up. And in this particular case, I mean, look, the council wasn't going to go and get valuations for every new dwelling that was proposed to be listed. Necessarily challenge those who decided to put one forward, but you need to decide on the evidence before you whether the costs, I suppose the private costs and the loss of opportunity to apply the MDRS, the significance of national significance of urban development, whether that is outweighed by the impact that not listing it would have on the failure to protect the heritage values that the dwelling represents.
I think you're telling me that the council itself hasn't considered that.
No, I think I'm saying, well, the council doesn't accept the evidence of Ms. Smith. It's a matter for you as to what weight you put on it. I'm going to just draw out a couple of flaws that I say are in that in that valuation, because of course it's for you to evaluate the valuation, and in my submission there are a number of obvious difficulties with it. And in my submission it's better to prefer the studies that have been relied on by Ms. Moira Smith.
Yes, that's a bit of a confusion. Too many Smiths.
Yes. But let me just
Tell me what you say are the flaws in that study, because I think that that's a lead.
so standing back, if you're going to try to work out what the impact of listing a dwelling as a heritage item is, you'd need to consider a number of sales of heritage dwellings and compare them to equivalent sales of non-heritage buildings to see whether there's a price differential. And as it happens, we have a number of such studies out of the UK, Australia and Auckland, which Ms. Moira Smith has referred to. That's where the plus or minus 10% comes from. But what Ms. Nina Smith has done is undertaken a direct sales comparison and selected a number of apparently equivalent properties at part 10 of the report. Now, I think there's 15 or 16 properties. The first one is not a heritage building. The second one is not a heritage building. In fact, none of them are heritage buildings until the very last one. And a number of them as well are leaky buildings, which is not what Dr. Kerr and Ms. Cutton's property is. And what the conclusion is that based on the analysis of sales, there's an indicated market value as is of just over 1.5 million. But there's no explanation as to how the conclusion then reached is that the market value as if heritage listed would be merely 1.1 million, because only one of the properties was was a heritage building. And oddly enough, it has one of the highest net rates in the table on page 24. So the reasoning is on page 20. Staple is cut it off. 25 under the heading 11.3.1 sales discussion. 4 paragraphs down. Based on our analysis of the sales evidence as recorded above, we consider that a fair and reasonable value range under this direct comparison method, having regard to market movements since some of these sales have occurred, would be between 1.4 and 1.7 for the property as is, and between 1 and 1.2 as if heritage listed. Now, I can understand where the 1.4 to 1.7 has come from as a general range for the property as is, but there is simply no reasoning to justify the 1 to 1.2 million other than generally Ms. Smith's experience. But based on the evidence that's in the report, there is no evidence of that. There's then an attempt to cross-check it, you might say, using the net rate method. And again, there's no reasoning. In the third paragraph under 11.4, Ms. Smith writes, we have adopted a low rate for the dwelling at $750 per square metre for the dwelling as is, and $250 per square metre for the dwelling as of heritage listed. So that's 1/3 the net rate for a heritage listing with no explanation as to why that number is being reached. This is said to reflect the current condition, which is the same whether it's heritage listed or not, but also the added time and cost to maintain a heritage listed property, together with the loss of amenity and quiet enjoyment of the property with restrictions that the heritage listing would impose. Now, I could accept that a heritage listing may impact the quiet enjoyment of the property, but I don't understand how it could result in a loss of amenity.
That might be because of the difficulty in improving the amenity.
There's no loss of amenity. The building is in its current state as is. As the report notes, it's in that state because of deferred maintenance, which of course you would have to assume was taken into account in the sales price of that Dr. Kieran was cut and paid for the property in the first place. I'll also just note another problem, which is that if you look at the mathematics, the arithmetic on the right-hand side of page 26, having decided that the rate for the dwelling as is 750 per square metre, it's then calculated on 1,000 per square metre, which artificially inflates the adopted amount by about $60,000. If you redo the maths on 750. There's then an unexplained difference in the value apportioned to the land value between the as is and the as if heritage listed amounts of $300,000, which accounts for the main difference between the two comparisons. And while I'm sure there would be a difference, there's no explanation as to why those two numbers are adopted.
Thank you, Mr. Wellington. I ask my David.
Thank you. Good morning, Mr. Whittington. I've been listening intently. A lot to take in, particularly on the Waikanae case. And most of my questions have been ticked off as you've gone through the discussion with the chair. I guess there's three matters for me. The first is the surprising outcome that you refer to is indeed a surprise, particularly when you look at policy 3 and policy 4. Seems to be counterproductive. The decision seemed to be counterproductive to policy 4. Sort of be given with one hand and taken away with the other. So
that's right.
How you can actually exercise qualifying matters or related matters under policy 4 without going through the IPI process is something that I can't understand.
There's also a point related to that, which is made in the submissions on behalf of, I think it's Kapiti Coast, which is that if you take the reasoning and apply it even to a Schedule 1 process, it's not clear that it can go through Schedule 1 either.
Okay.
I can.
I certainly hadn't picked that up.
Yes, well, it's at paragraph 2.12 on page 5 of the KCDC submissions. They say the court's interpretation of section 77I leaves it open for a party to argue that even under the normal Schedule 1 process, the council is unable to protect the urupā beyond making the MDRS less enabling. The reason for that is that the duty under section 77G is an ongoing one.
Okay.
So the council is therefore obliged to ensure that the MDRS are incorporated in every relevant residential zone in any future district plan review, in any future plan change.
Yes. Okay. The decision by Judge Dwyer, does it apply equally to all of the matters in 77I, A to all the mandatory or prescribed matters, 8 and 8E, or is it just the Section 6 matters?
Well, to the extent that it applies to Section 6 matters, it doesn't apply to existing.
Yes, and I'll come back
Matters.
to that in a minute.
Well, by definition, a Section 77I J, 1J matter, so in any other matter,
Yeah,
you're not.
I'm not worried about J at
Let
this
me bring
stage.
up-
That
let
was
me-
more the prescribed or mandatory ones under A to I.
So the Section 6 matters.
Yes. Infrastructure, heritage, hazard.
Yes, I think it must.
Yes.
There's no reason to
broad sense.
distinguish. Yes, there's no reason to distinguish heritage from any of those other matters.
Okay. And of course, if we go on to 77I little j, that presumably suffers the same fault.
That's right. And of course, you can't have a 77I J existing
No.
qualifying matter. They have to be established from scratch.
Yes.
And so by necessity, it means that anything within that would have to go through the Schedule 1 process.
Seems counterproductive, but that takes us on to the role of 77K, which is, as I understand in broad sense, is existing qualifying matters in an operative district plan.
Yes.
Now, Hutt City have exercised 77K in relation to existing heritage areas. Whether that's sneaky move or whether it's valid or not, I'm not too sure. But the advice from Mr. Quinn is that it is valid in its inquiries.
No, and I would agree with that.
Yes. So, for example, there are 10 heritage areas in the IPI, of which 4 are existing carryovers.
Yes.
And 6 are new precincts. And all of the existing heritage listings have been carried over largely without modification unless they've been destroyed or whatever reason. So
Yes.
they're exercising the 77K pathway, which involves some form of analysis, but not the same rigor as L and J. Yeah. Okay. Are there any 77K matters that apply to Wellington City? That might be a question for Mr. McCutcheon.
Well, yes, there are, in the sense that if you take the existing heritage listings in the operative plan, the evidence that you'll require to, I suppose, roll them over, for want of a different word, is less than for brand new heritage listings, for which 77J applies with its full rigor.
So in terms of the answer you gave to the chair about, well, what does this mean if we've got Judge Dwyer's decision and we can't distinguish it, and I'll come back to the distinguishing matter in a moment. You say you agree that the heritage would have to go through a Schedule 1 process and start again. That is the exception to that, the 77K matters?
Yes, so that would only be the new heritage matters.
Yes.
So what I'm saying would have to be re-notified to go through Schedule 1 would only be those dwellings and buildings and items that are new to the plan, and the ones that were already in the operative plan wouldn't need to be re-notified.
Can I test that? Of course, the HUD situation is where you have a plan change overlaid on a operative plan. Here you've got a complete review where, like, it seems to me that the purpose of 77K K is that if you've got a section 32 analysis that meets the standards in 77K, then you can just leave the provision in the plan as is. But here, of course, we've got a complete review where from one view, every provision is new because it's going to entirely replace the ODP. You know, it's not a case of...
Yes, what if you were simply doing a plan change, let's say you have a schedule that lists properties by address. If you're adding 10 addresses to it, then they have to be part of the plan change, but the existing addresses do not.
Correct.
I'll
I'll ask my colleague whether that's in fact Hutt has done, but let's just...
Well, it is. It is.
They've just left them.
So to go back to that, so if existing heritage, well, let me think about that.
There's a danger of perhaps conflating the weighting of and the legal effect of provisions through the proposed plan versus the process that section 77K anticipated would happen for qualifying a qualifying matter that's in an operative plan. So in broad terms, I understood that what 77K was saying was the mahi's already been done largely under the operative plan, unless there's a reason from departing from that, and you can explore that through 77K, then there's no problem with carrying them across. As to the legal effect and weighting of those provisions, but they're in a brand new PDP review, that's another issue. But I just wonder if there's a danger in conflating those two matters.
As I'm reflecting on it, I think the position that I first put to you has to be right. I'm just going to check the wording, the chapeau in particular of 77K, but
A specified territorial authority may, when considering existing qualifying matters, instead of undertaking the evaluation process in 77J, do all of the following things, X, Y, Z.
now the concept of an existing qualifying matter is a little odd because it presupposes that the operative plan has gone through a process of reducing the impact of the MDRS, whereas no operative plan yet gave effect to the MDRS. What 77K was added to the bill as it was going through, because I think it came in at the select committee stage, what it responded to were concerns expressed by councils in particular that all of the work that they have done establishing, for example, heritage items in their operative plans will have to be redone, potentially to a higher standard, and relitigated through the IPIs, which will increase the huge amount of work that they will need to do in an incredibly tight time frame, and increase the amount of hearing and decision-making time that it will take up for people such as yourselves to have all of these matters relitigated. So I do think what it is talking about as a concept is reasons that are already in an operative plan why you would not make the MDRS or policy 3, why you wouldn't give effect to them to their fullest extent. So for example, a coastal hazard area, if there's one already in the plan, you don't need to go through the airport noise boundaries. You don't need to go through the full justificatory process of explaining why you're not giving effect to the MDRS in particular areas. When you then apply that to the Wellington City Council, which has a new, I think 77K applies specifically, or perhaps it's perhaps designed most for a city like Wellington City, which is notifying an entirely new plan. In your Hutt City example, if existing heritage items are not being included in the IPI, I think you still have to go through the 77K process for those items
you'd still need a Section 32 evaluation or a 77K evaluation,
Yes,
but but something that's not there
that's right.
is not in the IPI process.
Yes, but you still do need to go through that because the effect of those listings will be to change the way the MDRS will apply on that particular site.
Yes, I might have led you astray though. I think the four existing are part of the IPI. That's obviously subject to submissions.
Okay.
So they are part of the plan change. As really thought it through, but
No, well, that makes more sense to me that they whether or not they're part of the IPI, there does have to be some background analysis. To say why for those matters, the MDRS won't apply on those heritage dwellings to those heritage sites, because they will have the effect of reducing the application of the MDRS. So there does need to be that analysis. Perhaps you probably wouldn't need to relist them because it's a plan change and you're not proposing to change anything.
but in the event HUT have.
But in the event HUD have, which I think I would have said is the better course.
The interesting thing is whether on a machinery motors, anything other than what's in the plan change could be the subject of submission, because by definition it's not different.
Yes, yeah, that's right. Although I also don't think that what's it called, motor machinists.
Motor machinists, no, you're wrong one.
Yeah,
you're wrong, guys.
Yeah, I mean, my position is that just does not apply.
Yeah, but so where have we landed? Are you saying that you've circled back to your original quick answer to Commissioner McMahon holds that you think this is just matters that are not in the ODP?
Yes, that's right.
That are in issue based on
Waikanai Land Company.
Waikanai Land Companies. Sorry, Commissioner.
That was all. Actually, one last question, Mr. Whitting. You did say, I sort of returned to this, that the KDC decision or decision of the court is distinguishable with Wellington City. Is that both at the broad level and the detailed level, or just the detailed level? Because at the broad level, what I heard you say is that what the court has said is that it's not vires or it's ultra vires to include a new listing under the IPI process.
What the court says, there's two aspects to the court's reasoning, but if the part of the reasoning that holds is that KCDC went too far in putting forward new fencing rules with a change of activity status and new earthworks rules with a change of activity status, then it's simply just, if that's the part of the reasoning that holds, then it's distinguishable because the Wellington City Council plan does not do that.
But that's sort of ironic in a way, because if you were going to have any, are they the related provisions, aren't they?
Yes.
There would be fencing and earthwork provisions, wouldn't it?
Well, that's right.
That's squarely in that inclusive.
That's right. And I've highlighted in my submissions a passage from the Select Committee report that expressly refers to both earthworks and fencing. Yes. And earthworks and fencing are listed in section 80E2. Maybe fencing is absolutely.
Yeah, I think it might be. But anyway,
it is. Yes. So,
that's the way they've done it.
Yes.
What they've done though is that distinguishable. The method of doing it, the rules, the concept of applying a heritage matter as a qualifying matter under policy 4 to limit intensity and height or density and height through the IPI.
No, that's not distinguishable.
No.
Because that is
That-
what
that's
the
government,
council
isn't
has
it?
done.
Yeah.
But I think generally the point I would make is that we have national planning standards and they seek to guide how plans are drafted, but there is still a degree of discretion about how you go about things. Some councils might prefer to have heritage precincts. Another council might prefer to have a heritage overlay through which the heritage provisions work. Other councils may prefer simply to zone, have specific zones that incorporate the rules that might apply to say heritage areas. The legislation doesn't seek to change or control that. It allows councils the freedom to still go about drafting the plan in the way that they want to. And that's why I say that you can't say new heritage listings can't be in the IPI because of the related provisions, part of section 80E, because the way one council might do it might require them to rely on that, but the way other councils might do it will not.
So certainly there's been considerable differentiation across the region. For example, the sort of character areas that we've been referring to in previous hearings and this hearing as a section 77IJ matter have been proposed in Hutt City as heritage areas, section 6 matters. Yeah.
And we have the argument in this hearing that Kainga Water is making that it's called Mount Vic North Townscape area is really a heritage matter, not a townscape precinct.
And of course, historic places Wellington are making the same argument on a broader scale, saying all of the character areas should be heritage areas.
Yes.
It's ironic because the higher order document in this case, one step up is policy 21 of the RPS. And it's the way that that's been applied across two adjacent territorial authorities is quite different. No question there. That was all for me.
Yep. I think that's it from us. I noted that you're gone away to think about something that I wrote, pondered. Oh yes.
The Human Rights Commission.
And the time frame for the
Yes.
High Court. And so if you just float that in whenever you can get us an answer, accepting that at least certainly for the last one, it's maybe no answer because no one knows.
That's right.
But we'll wait that development. I think we're up to Mr. McCutcheon.
We are.
So, Mr. McCutcheon, how do you intend to proceed? Like you've got a very substantial Section 32 report. You've got a very substantial supporting brief of evidence from Ms. Smith. How are you going to handle the juxtaposition between the two?
Thank you, Mr. Chair. It's good to be before you again today, the second time in only a few months. What I propose to do is to introduce myself. Then I will pass to Ms. Smith, who will introduce herself. Then I'll give a short introductory statement and then hand over to you for how you would like to cut and dice the 42A report.
I think we're scheduled to have morning tea at 11:40, but if we have, or 10:40, thank you. If we have your introductory statements, then we'll break and I'll discuss with my colleagues the best way for everybody to handle the weight of material you put before us.
Excellent. Can do. So for the benefit of everyone online, I have introduced myself to you before in Hearing Spring 1, but my name is Adam McCutcheon. I am the Acting District Planning Manager at Wellington City Council. I was a reporting officer on Stream 1, which was concerned with the strategic direction chapter and overarching matters which affected the whole structure and format of the entire district plan. I've been at the City Council for almost 4 years now, and I've also held team leader and senior planner roles within this organisation. Prior to that, I was at the Ministry for the Environment for also close to 4 years, where I was part of the team which developed the National Planning Standards, which we've spoke about this morning.
You'd love to answer for me.
Yes, I'm usually rather coy about my previous involvement in the ministry, but I was also part of RMA changes, so none of the ones we're discussing right now. So my qualifications are that of a Master of Planning with distinction from the University of Otago, as well as a Bachelor of Arts in Geography. I'll hand over to Ms. Smith to introduce herself.
Kia ora tātou. My name's Moira Smith. I'm a conservation architect and a heritage advisor. I have primary degrees in architecture. It was building science and architecture when I went through. I've been a registered architect in the UK and in New Zealand, and I've worked in for Wellington City Council for about 10 years in a variety of roles. So what it means is that I've done the conservation architecture part of it, but I've also looked at resource consent assessments and the things that a heritage advisory council would do. And I'm currently self-employed as a consultant conservation architect. Thanks.
Thank you, Moira. So one of the themes that we've heard over the past 4 years of engagement on the spatial plan and the draft district plan process is how the community wanted to see significant places and their values identified, recognised and protected as the city grows and changes. In the first 2 hearing streams, we've heard much of what this transition will look like and the scale of change which could occur within our environment. Places with significant heritage value help the community to understand about culture and history, provide a sense of place, identity and well-being. They connect the past to the present and weave it into the future. Historic heritage, as we've known and we have discussed this morning, is a matter of national importance under Section 6 of the RMA. This hearing, of course, addresses historic heritage in the context of buildings, areas, archaeology and sites of significance for Māori. It also addresses view shafts and notable trees, which my colleague Ms. Stevens and her experts will talk to. Notably, the hearing and the topic we're discussing today has been undertaken, and the work to support this conversation has been undertaken in a continued and conspicuous vacuum of direction from central government. There is no direction guiding how to recognise and provide for these matters of national importance and what the resultant thresholds and trade-offs tangibly look like. Best we have is policy 21 and 22 of the regional policy statement. Accordingly, the provisions that we're here to discuss today have been informed by building upon those of the operative district plan, engagement with practitioners, Heritage New Zealand Poheritanga, the regional policy statement, engagement on the spatial plan and the draft district plan, and importantly, the objectives of the strategic direction chapter. Positioned within the clear context of the MPSUD, which we must intensify the city's built form in the pursuit of the creation of a well-functioning urban environment, the perceived tension between protecting heritage and enabling growth and change has, in my view, increased. I have recommended a raft of changes across this chapter to respond to the somewhat polarised views of submitters, while in my view still fulfilling our statutory requirements. Contextually, the review of provisions for historic heritage takes place within the context of 130 heritage places being identified as earthquake prone, approximately 20% of the total number of buildings within the city that are prone to fail in a large seismic event. A peak of expiry of earthquake prone building notices is expected to be reached in around 2027. Given this challenge, it is important that the provisions of the PDP find a reasonable and certain regulatory pathway for buildings to be strengthened while balancing heritage effects and ensuring that all other alternatives have been exhausted before total demolition is considered as the final option. A significant database of nominations of heritage places has been compiled from Wellingtonians over the life of the operative district plan. They total over 600 in number. A considered process has been followed to prioritise what limited resources there are to identify places for addition to the heritage schedules. These places were identified because of their status and recognition by Heritage New Zealand as being places of national importance or significance, their ability to increase the representation of the heritage schedules and the diversity of stories, themes and cultures represented by it, and for their exemplary qualities. To that end, the proposed district plan's strategic direction sets a vision that heritage places are retained and resilient and a sustainable long-term use is enabled while heritage values are protected. Relatedly, a significant body of work has been undertaken alongside our mana whenua partners to develop new sites and areas of significance to Māori provisions. The aspirations of mana whenua were clearly articulated to Council as having a genuine opportunity to increase the visibility and prominence of cultural narratives within the built form of the city as it grows and changes. To this end, the strategic directions guiding sites and areas of significance to Māori provisions seek to increase the representation of Māori cultural values and their relationships to sites and areas of significance within this built environment, and recognise that mana whenua are the only people who can fully identify the effects of development on their relationship with te tao. The resultant provisions and the changes that I have recommended move away from a more typical first generation plan approach of being concerned about land disturbance to nuanced and intentional rule triggers, recognising the different values that places have to mana whenua and the reasons they are identified within this plan. It's an approach which I do recognise district plans don't usually take in such strides particularly. On the other hand, the notable tree provisions seek to increase the clarity and intent of clarity and the extent of certainty from the operative district plan. New standards have been added specifying the qualifications which must be held by people undertaking works on or around trees. I've also recommended changes that help reduce repetition and duplication with the related infrastructure chapter and respond to the views of submitters with technical expertise and practical experience. I look forward to the discussion today and most likely tomorrow, maybe even later on within the week, we will see. And I thank you for your time. I'm also looking forward to morning tea.
On that note, we'll break for 15 minutes. We're a little early. We'll be back at 10:30 with some ideas about how we'll go from there. We'll restart the hearing. Mr. Wellington, as these things I want to do, we thought of another question for you. Not expecting an immediate answer, but if you could add this to your list of things to ponder. Both you and counsel for Pairua and KCDC have all told us that we're not bound by the Environment Court's decision in Waikanae Land Holdings. The authority for that proposition are cases that relate to the Environment Court decisions, not binding other divisions of the Environment Court. Can you give us any case law that tells us that we are not bound by the Environment Court? Because making a blinding statement of the obvious, we are not the Environment Court.
And I think that's the answer. I certainly don't see this panel, but councils in general is in a direct line of authority court system, if I can put it that way, rather than appeal from a council is through the Environment Court. It still means that council down on Environment Court system. But I certainly look for the other answer to that. Environment Court decision provision in the case of DC, our provision. That's the same reason why. I can give you another update.
I'm not sure that's no news is good news category.
I also reflected just about one of the answers I had given you. No, that's not. Thank you for
I think people online.
yes, no, thank you for pointing that out. I was reflecting about one of the answers I gave you, which was the answer about if Judge Dwyer is right, what do we do? And I said you only need to notify the new ones, and I don't think that's right, having reflected on it. The answer was sort of then given by reference to 77K. We have the different processes, but the fact that we have the different evidential processes to establish the qualifying matter doesn't make a difference to the process that a heritage item should go through. And that's, I think, a reason why the court must be wrong, because it's directed itself to the question, is a new heritage item able to be put through the IPI, and come up with the answer no. But while there's an evidential distinction or a process distinction that the legislation draws between existing and new qualifying matters, it doesn't draw a distinction at the level of how qualifying matters go through the IP, whether qualifying matters go through the IPI or Schedule 1.
So, and
in other words, I think what the court has done is not just determined whether new qualifying matters can go through the IPI, but effectively whether any qualifying matter can go through the IPI. That's one way of reading the decision.
that its reasoning would have that effect.
Yes.
Like it hasn't determined that because
No.
it was facing.
That's the corollary of its reasoning.
Strikes me that we should ask you, therefore, as part of the council's reply, not now, not in 10 minutes, and probably not for several weeks, if you could give us a list of the provisions that would be in that category I suspect it will be a long list.
And I think we need that sort of that sort of thinking distilled into writing too.
Yes.
Yes, I can do that.
I certainly understand what you're saying. That's one thing to do the assessment and see which path it goes through, or how it qualify the qualifier
Yes.
exists. But then you come back to the role of the IPI, and as I said at the start, that seems to be counterproductive to policy 4. But yeah,
Yes, the now, Mr. McCutcheon, we've had a discussion about how we want to proceed, and we think that we will compartmentalise your 42A report. What we'd like to do is go through the aspects of your report that relate to the objectives, policies and rules governing historic heritage, then swap to Ms. Smith to hear her evidence effectively about the schedules and what's out, and for those things that are in, how they're described, and then revert to you to for you the parallel provisions of passages of your 42A report. But before so I think that that's our modus operandi. But before we start, what we would like is for you to give us a high-level overview about the structuring of the historic heritage chapter. In effect, how is it structured? What's the rule framework, and what are the key rules and key defaults, key rules, key default rule statuses, key defaults?
Certainly, Mr. Chair. So the historical and cultural values are part of the proposed district plan. That is a bucket which we were provided to put provisions in chapters by the national planning standards. One of the chapters we must use if we are to manage historic heritage is one of the same name. So the historic heritage chapter contains the provisions which manage works to heritage buildings, these being buildings that have been assessed against Policy 21 of the Regional Policy Statement as having significant heritage values. And as you would have seen from the evidence provided online on the website, there are detailed heritage reports which sit behind not just the newly proposed heritage buildings, but all the existing ones as well. This chapter also addresses heritage areas. So heritage areas are areas which have collectively values that meet Policy 21 of the Regional Policy Statement. They're a planning tool that's used within the operative district plan as well. Within heritage areas, there are a number of buildings and structures which might contribute at different levels to the values of the heritage area and its meeting of the Policy 21 test. Some of these may be individually listed, so they're contained on Schedule 1 and also happen to be within a heritage area. The plan makes it clear that where that is the case, the heritage building rules are the ones that we're looking at. There are buildings which contribute to the values of a heritage area. So they make a positive contribution to the qualities that are intended to be protected by the provisions in the chapter. So these are known as contributing buildings. There are also structures which contribute as well. There are also buildings and structures which don't make a contribution. They may have a negative impact on the heritage values of that area, or they might have different values, but they're not in keeping with those which are being protected by the plan. These are known as non-heritage buildings and structures. Both the contributing buildings and structures and non-heritage buildings and structures are identified within Schedule 3 of the plan, which is concerned with heritage areas. I should also note, alongside heritage buildings, we have heritage structures. So these are things, they might be monuments or memorials, they may be tram poles, or they may be fountains that have significant heritage values, and they're contained within Schedule 2. So the historic heritage chapter addresses, in addition to heritage buildings, structures and areas, addresses scheduled archaeological sites. These are a new proposition in the proposed district plan, and one that has been recognised in the operative district plan for a couple of decades now. So what they are, and the sites themselves are identified in Schedule 7, I believe. Oh no, Schedule 4. What they are archaeological sites which have been assessed against Policy 21 of the Regional Policy Statement as having significant values. So there are many thousands of archaeological sites across the Wellington district. We're sitting at one at the moment. The city centre is an archaeological site in of itself. So the provisions contained within the Historic Heritage Chapter for scheduled archaeological sites are not intended to apply to all archaeological sites, only those with significant values that have been assessed and added to that schedule. Other more general archaeological sites, which are pre-1900, where areas where there's evidence of pre-1900 human activity, would be managed by Heritage New Zealand through its archaeological authority process. That's the historic heritage chapter. If you would like, I can also talk to the notable trees and sites and areas.
I think we'll do one thing.
That's enough for now. Cool.
And the plan structure.
So in terms of the plan structure, the chapter has 3 objectives which apply to all of the forms of identified historic heritage, so buildings, structures, areas and archaeological sites within this chapter. Those objectives are grouped together. We then flow into policies, one which applies to all historic heritage.
Is that policy 1?
Policy 1, yes. Policy 2 through to 6 are concerned specifically with built heritage. And built heritage is defined in the plan as buildings, structures and areas which relate to Schedules 1, 2 and 3. The reason that there are specific specific policies there, 5 specific policies, is because there are certain types of works or activities for which a bespoke planning approach is adopted for built heritage, as opposed to scheduled archaeological sites, which have a different intent of the provisions in managing a different form of historic heritage, which has specific requirements. We then move into policies specifically for heritage buildings and structures. They're concerned with works to buildings to increase or decrease their mass.
Can you just say that again?
Policies 7 through to 10 specifically relate to heritage buildings and structures. so schedules 1 and 2. Policies 11 through 16 relate to Schedule 3, heritage areas. You'll notice a degree of commonality in the types of activities which are being managed and their thresholds and parameters set in these policies. There's a commonality between Schedule 1 and 2 and 3 items. Policy 17 through 21 specifically relate to scheduled archaeological sites. There's a different focus, recognising there's different levels of fabric or different values which require a specific management approach to protect those heritage values. That same pattern of grouping rules for Schedule 1 and 2 buildings and structures separately to heritage areas continues within the rules which then follow below the policies. So we've got rules that relate to buildings and structures, and then another set of rules which relate to building heritage areas, and then another set of rules which relate to scheduled archaeological sites. The activity statuses which have been applied to the rules seek to enable and encourage and permit works which will have neutral or positive effects on heritage values in the context of the strategic direction of the plan. And let's not forget the strategic direction and what that tells us these provisions are to achieve, and heritage being retained, resilient, and having a sustainable long-term use. So the permitted activity rules enable maintenance and repair. So works to increase the weather tightness or repair damaged and deteriorated fabric or parts of a building to prevent further decline. The recommended activity statuses for works that may have impacts to a building, like the double glazing and modification of windows, adopt a controlled activity structure, controlled activity status, recognising that there are trade-offs which need to be made in terms of ensuring that heritage values are protected, as well as achieving the strategic directions around places having a sustainable long-term use and enabling improvements to buildings that increase energy efficiency. They have a controlled activity status and are contained within rule number 5.
Mr. McCutcheon, just on there is that's a red track change rule. So is that's the 42A position as opposed to the notified position, isn't it?
Correct. The notified proposed district plan provision was a permitted activity.
Okay.
I turned my mind to the feedback which was received that might not necessarily protect heritage values and could lead to adverse effects, where there was essentially no regulation until perhaps after the fact enforcement of works that might have strayed outside of the thresholds envisaged by that permitted activity.
And I wrote down earlier that you said you'd made a raft of recommended changes to reflect the polarised positions that came in through submissions on these. So
Correct.
A little bit more heritage protection in that particular instance.
Correct.
But certainty as to the outcome. What's this? Well, subject to conditions.
Subject to conditions. So in my view, a controlled activity status would give the certainty that a consent could not be refused, but there would be a degree of control available to planners and to heritage advisors to ensure that there were good heritage outcomes which could be achieved through alongside increasing energy efficiency and creating healthy living environments for people who own heritage buildings.
And that particular change was done effectively through the definition of maintenance and repair,
Correct.
necessitating then a new rule.
Correct. So there's something of a spider web of recommended changes in which previously this had been permitted by way of that definition, but in removing that clause from the definition, it was necessary to create a specific controlled activity rule, which is why there's quite a substantial amount of policy renumbering and rule renumbering that has taken place as I've inserted new rules to respond to the concerns of submitters. Similarly, in the permitted activity realm, there was a submission seeking that temporary works and invasive seismic investigation of buildings be permitted, so as to reduce barriers for incentivising building owners to take initial steps to understand the vulnerability of their buildings or not. And I agreed with these submitters that that would be beneficial, but also asked for some advice from them, or put the offer out there for some advice as to how what standards or thresholds should also be placed around those rules. Another significant, another change which I have made from the notified provisions is concerned with the visibility of internal seismic strengthening from heritage buildings and new floor levels or mezzanine floor levels which are visible from the exterior. You'll note that in my section 42A report, there's something of quite a substantial commentary under the assessment of policy HH-P3 around internal works, where these submissions first started to come in, where I have assessed internal works to both heritage buildings and within heritage areas in the round, so to speak, and have made recommendations which then would flow into the relevant assessment of the notified policies and rules.
And then I think in the renumbering that becomes P4.
Yes, it does. Yeah. So on this, the submitter group, the heritage professionals, had concerns about the visibility of internal seismic strengthening from the exterior of buildings, and that they did not offer an activity status from memory that they sought, but they had concerns that it would result in adverse heritage effects. I agree in part with them that yes, there can be effects on the values of heritage buildings, or certainly the appreciation of those values from a visual point of view when strengthening is visible, particularly if a building is managed for its perhaps exemplary architectural qualities. K-bracing or bracing elements through shop front windows may be highly prominent. The notified plan had this as a permitted activity. I've recommended this make its way back to a controlled activity, which is less restrictive than the operative plan. So the operative plan approach is restricted discretionary. In finding a balance between protecting heritage values and achieving resilience outcomes, I don't think it would be an acceptable outcome that we would refuse internal seismic strengthening solely on the basis that it's visible from where it is visible from the exterior of the building. And I certainly appreciate the commentary that the heritage professionals made that better outcomes can be achieved through the resource consent process to perhaps position it in, as I understand it, position it in ways that are less noticeable or achieve design, modify the design of the strengthening so that it sort of fades into the interior of the building. So On that basis, I've recommended that this be a controlled activity status with matters of control around the design and external appearance and how much heritage fabric needs to be modified. I also don't consider that this should be subject to a notification assessment and that it should be a non-notified resource consent process, which is the same notification status I've recommended for works to windows. I've also recommended a change to the creation of new floor levels. Again, my assessment and some pictures to demonstrate what is attempted to be regulated is contained in that assessment of policy 3 in my 42A report. This is one where in the notified version of the plan, it is restricted discretionary. The Heritage Professionals Group would be supportive of that status, but there were developers who, in the context of seeking to reduce barriers to places having a use and reducing regulatory barriers to using buildings whose floor plans and internal design, layout and structure might not necessarily achieve a level of floor space which is viable for a use to occur, sought that a lesser activity status be reached. In my 42A report, again, I show some photos of mezzanine floors through windows, which is what is, and new floor levels, which is what is the outcome that would occur. And I agree that there are some, through the resource consent process, heritage advice can be sought to ensure that those new floor levels can be positioned in a way perhaps that reduces their visibility from the outside and any cutting up of large windows so that it looks a bit awkward and reduces that appreciation of heritage values. Moving into the additions and alterations rules. The additions and alterations and partial demolition rules seek to manage works to, for example, add apartments on top of buildings or to the rear of buildings, to undertake works that aren't captured by that definition of repair and maintenance. So that this is the rule that will be used the most, I'm picking, and assessed against the most. It also is concerned with partial demolition of buildings. So when bits of buildings are to be removed and perhaps they won't be replaced, so the floor space is getting smaller. But partial demolition, of course, is necessary if you are making a modification to a building anyway, where you've got to remove bits of a building to put new bits back on. So it serves both purposes there. The heritage building rules, and this is where the discussion on do they curtail the MDRS is evident. They are concerned with the construction of new buildings and structures on the same site as heritage buildings and structures. So next to us is Antrim House, beside this great big vacant building. In the back is Antrim House. You'll see it in the tea room down there. That's a heritage listed building. New buildings that are to be built on the same site as that building require a resource consent. And that's focused on ensuring that the design, scale, location of new buildings and structures pay attention to the setting, the materials and the values that listed buildings have. There are permitted activity standards in here with respect to the medium density and high density residential zones. And these are to enable property owners to have a reasonable level of use of sites so that things like garden sheds and sleep outs aren't captured by these rules. It wouldn't be effective or efficient in my mind to have building owners apply for resource consents for small garden sheds. They also allow structures, small scale structures, things like fences and letterboxes. Again, I don't think we should be in the space of consenting letterboxes. The default activity status for works to heritage buildings, though, that don't meet those standards and for new buildings on the sites of heritage buildings and all other zones is restricted discretionary. Recommended Rule 9 is concerned with additions and alterations to non-scheduled buildings and structures on the site of heritage buildings and structures. So I note that in the expert evidence, I think it was for Kying or Aura perhaps, there was a suggestion that a definition of non-scheduled buildings and structures be added, and I have agreed with that expert. So what these are, in the same way that I just discussed garden sheds, there will be existing buildings and structures, particularly on heritage buildings that are on very large sites, which are not related to the values or don't contribute to those the values of that place, so need not be subject to the same thresholds and standards for repairs and maintenance. What we are concerned about, though, is where the floor area or the footprint of that building might increase in size, such that there be a detraction of the appreciation of the values of the place that is actually protected by the heritage provisions, the scheduled building or structure. There again are permitted activity thresholds in there, and if those are not met, restricted discretionary is again the default status. We then move into works and activities which are to do with moving buildings, and the default activity status, instead of having permitted activity standards, steps up to restricted discretionary. And we start to see how some of those principles of conservation planning about enabling and supporting low intervention works, whereas regulating more closely and strictly works that are more likely to have adverse effects on heritage values, is reflected within the hierarchy of rules in the plan. So sometimes buildings need to be moved on their existing site. This might be because, as set out in Policy 9, there are natural hazards which need to be avoided. We don't want to have buildings washed away from streams, so moving them further away from a stream, for example, might be a better outcome. So the recommended Policy 10 relates to Policy 9, recommended Rule 10 relates to Policy 9, which sets out thresholds where buildings may be moved on their existing site. This is generally recognised as a better outcome than moving a building from its site and relocating it, where severing of any values attributed to location and setting can occur. Because of this, relocation of heritage buildings and structures is afforded a discretionary activity status, with some specific information requirements recommended around why this activity needs to take place and what reasonable alternatives have been considered in reaching the conclusion that a building must be relocated. Moving back to Rule 11, removal of unreinforced masonry chimneys from built heritage is a new policy and rule approach in the PDP, which to some extent reflects current practice in the consenting space for works to heritage buildings on a more informal basis. I've set out in my 42A report how there is a regulatory misalignment, so to speak, between the Building Act and what works are enabled in light of learning from the Christchurch earthquakes about chimneys, where removal of unreinforced masonry chimneys does not require a building consent. They do, however, require resource consent under the operative plan as a restricted discretionary activity, but there's no policy framework which sets out whether that be a desirable outcome or in what circumstances should a chimney be allowed to be removed. I set out in my section 42A report how there may be a bit of a misalignment between the related activity statuses for works to windows on heritage buildings and on works to character pre-1930s buildings within the character precincts, and the tests that are set out for the related removal of related bits of buildings, where those tests may in fact be tougher, and I've drawn your attention to those. I've noted in my section 42A report that if there were scope, or if the panel were of the mind or of the view, I could support this activity, but also being controlled, and some of the tests eased a little bit there. What it's trying to do is recognise that there can be sort of easy wins in increasing the resilience of places where parts of buildings are likely to fail, and might be the reason that a building is identified as earthquake prone, where it's not the majority of the structure but only one feature, and setting out a pathway for satisfying a reduction of risk, and an earthquake prone building notice might be desirable. Considering the total demolition of buildings, heritage buildings and structures, these have a discretionary activity status. In the operative district plan, a restricted discretionary activity status is afforded, with an assessment solely on heritage values. Discretionary activity status broadens that consideration. The policy test for total demolition of heritage buildings is very similar to that of the operative district plan, in which a decision maker needs to be convinced that there are no reasonable alternatives to total demolition. So this is the test of the operative district plan. The operative district plan provision, the policy approach appears to be working to prevent the demolition of total demolition of heritage buildings, where I have noted in the issues and options paper, only a small number have been consented for demolition, and there have been, the ones that have been lost have had extenuating circumstances that have applied to them, such as that they were designated or that they were demolished as under the emergency works provisions of the RMA, or they burned down. So what I've attempted to do in the policy for total demolition is give some context to what reasonable alternatives to total demolition are.
Which policy are we talking about?
P11 of the recommended sets of policies, and apologies, I think I was referring to the incorrect numbers right at the very start of my talk. Considering the total demolition, I've tried to give some context as to what reasonable alternatives are. So starting from the hierarchy of interventions, so the principles of conservation works and interventions, repair and maintenance should be considered as an alternative. I have accepted the submission of Wellington's Character Charitable Trust in part, where they seek increased recognition of demolition by neglect. I've done this by way of including reference to the extent to which maintenance has been regularly undertaken as part of that consideration of maintenance and repair. I note that by way of legal submission, Mr. Ballinger has offered some alternative wording, which I don't have any concerns with. I think it achieves the same intent, and I'm of the view to agree with that. In my 42A report, I set out the difficulties in the regulatory environment of managing demolition by neglect. We have no higher order national direction which addresses this matter, which is different to the environment of other places across the world. Excuse me, submitters have drawn my attention to the United Kingdom planning system, which does have a clear direction. Unfortunately, we do not, and there's no pathway that I know of, or I'm not aware that the government is intending to release anything in the immediate future to increase certainty in this space. So given the difficulties in the regulatory environment whereby council is really only has the opportunity as a last resort to slap dangerous or unsanitary building notices on people and enforce works at that point in time, I've recommended that the extent to which modification has been undertaken, maintenance and repair, pardon me, has been undertaken is a factor that is considered in weighing up a demolition consent for a heritage building. And part of the reason why I don't agree that a blanket policy to not consider maintenance, deferred maintenance as a reason for not to consider it in the resource consent process is because there are a variety of different reasons why buildings might be left neglected, recognising that not all owners are well cash strapped to be able to undertake works or to undertake what can be significant works in some cases, nor might they be able to achieve bank lending to do so. So there are some owners who get stuck in a little bit of a bind. So that a more considered approach to why a building might have been neglected or has this demolition consent come in recently after a building that was known to be earthquake prone or have significant deferred issues was purchased. Considering factors like that should be relevant in a resource consent decision. Clauses 2 through 5 of P11 talk to what the other reasonable alternatives to total demolition are, including seismic strengthening, as well as adding floor area or undertaking additions and alterations or partial demolition to enable reuse. So one of the things I've tried to be very clear about in my recommendations is that buildings are less likely to be neglected and are more likely to contribute positively to a well-functioning urban environment when they have a use and they create return for people and they are used by people within the urban environment. And that additions and alterations to increase building functionality or to provide for different uses may be necessary, and they should follow a consenting framework to do so. This recognises that there are some buildings which we list which are formerly wool stores, and they're in the city centre, and we don't store wool in the city centre anymore. So new uses are the only use for those places. That modifications might be necessary to support a co-working space or to support a shop going in. Accordingly, additions and alterations to buildings should be considered in a total demolition resource consent, whereby the economics or the viability of adding new floor level and renting out floor space or creating apartments on top of heritage buildings should be convincingly ruled out as not a reasonable alternative before reaching the conclusion that total demolition is the only option. The same goes for repositioning and relocation. They should also be considered before buildings. We reach the decision that total demolition is it. Would you like me to continue working through the rules?
Well, I wonder whether, rather than working through the individual rules, we should hold that thought for our detailed examination, because it might take some time.
That's been really useful. I just have one question, but no, in fact, I'll park it because it is more detailed.
Okay, well, on that note, well, it's I echo the Commissioner's thought that is really useful. So we'll start into your report. The same modus operandi as previously, Commissioners. I'll pick a section, see if anyone's go to where I start, and anyone's got something before that, we'll pick that up. start at section 4, general submissions, page 21. Any advance on page 21? Paragraph 80. Sorry. Hey, you've got to be quicker, Chris.
Yes, I do have some before 21. Mr. McCutcheon, in your paragraph 76, you are saying that with regards to emissions reductions, that you consider that the benefits are outweighed by reduced carbon emissions over the life cycle of a new building and a more intensive use of the site. You are telling us also that you do not have any quantitative research to this effect. On what basis are you basing your recommendations there?
Yes, so correct. I don't have any quantitative evidence behind me to prove otherwise. But as I said in stream 1, I would find my view would be, if you have a 50 square wooden building right next to the city centre zone, which could otherwise be enable development of 6 stories and house 100 people, it would seem perhaps obvious to me that over the life cycle of that building and related to the transport emissions that would be saved, the reductions in people needing to drive perhaps from Granada or further afield to work every day, where they can walk in this close to in a city location, that it would seem to me that there would be great carbon benefits over the life of that new building. I just don't. I've noted that I don't have any evidence, but it seems obvious to me. I don't disagree with people that buildings have embodied carbon in them, and that creating new buildings and undertaking new development produces carbon. Totally agree with that. But where we're talking about development in the right locations that help support, create a well-functioning urban environment and reduce the need to undertake, to travel by carbon reliant modes, the benefits seem to outweigh the costs of embodied carbon in some circumstances. It won't in all circumstances. Perhaps if a building is being demolished and a smaller scale one is going in its location, which has resulted in more carbon to produce it. Sometimes that does occur if you've got a multi-unit that's being demolished and someone buys it and builds a single house, then the carbon outcomes will probably be worse. But in the context of an intensifying environment, and if that's the scenario which we're considering in my paragraph 76, it would seem straightforward to me.
Have you considered in that reasoning that not every person who would live then in the apartment block would necessarily work in town? That there is a counterflow from people living in town that work outside or have, for whatever reasons, have to go outside, and that there is not necessarily a complete reduction of traffic apparent.
I have considered that, but by the same token, if you expand that scenario, you get to the position where we should not demolish anything at all, and we would not be able to achieve the intent of Policy 3 nor the MPS, which is seeking that we intensify the urban environment that we live in now.
When you say not demolish anything at all, we are not talking about any buildings here. We are talking only about heritage buildings that also have another value that is actually not necessarily accounting to monetary value.
So the submission, as I understand them, relate to buildings more generally. So my comments stand for buildings more generally. I think heritage buildings are definitely a different scenario where we have said we don't accept any loss of carbon and we don't want this place to be demolished, not for reasons that they have embodied carbon. That's not a reason that Policy 21 asks us to consider to add places to the schedule, but that they have significant heritage value and should be recognised and identified and celebrated for that. So I see that as a separate consideration.
Okay.
Yeah.
Okay, you are on 20. Thank you.
Paragraph 82, Mr. McCutcheon. The said council has a program waiving consent fees, heritage items, and you understand that will continue. Is that in the district plan? And if it's not, should it be?
So it's not in the district plan. It's one non-regulatory method which the council has in place to support owners of heritage buildings to undertake works, excuse me, which can achieve positive heritage outcomes. So up to $2,000, as I understand it, is available as part of a reimbursement. So you still have to pay for your resource consent, but then you are eligible where those works are supported by the heritage advisors for your resource consent to be reimbursed. I don't think it should be incorporated into the district plan because you might find that perhaps more money is obtained and a different program comes out which could achieve better outcomes. It wouldn't seem effective or efficient in my mind to then need to undertake a plan change to reflect that.
The devil's advocate might be, if it's not in the district plan, it could equally be the subject of the proverbial budget size and be removed entirely. Should we take any note of it from a Section 32 perspective? If it can come or go at the council's whim, and presumably it's in one of its operating plans.
I think it can be considered because Section 32 asks us to consider what non-regulatory methods there are out there that might achieve or support achieving similar outcomes. This council has shown an ongoing commitment to explore and have non-regulatory options for managing heritage values. Most recently, the former Built Heritage Incentive Fund has been refreshed as the Heritage Resilience and Regeneration Fund, which takes a focus on identifying and supporting buildings that are having resilience issue challenges, so they're earthquake prone, and that is afforded a level of funding from that annual plan and long-term planning processes. But you are quite correct, Mr. Chair, that the council could turn around and decide we don't want to do this anymore in a budget cut sense.
More generally about paragraph 84 of balance between protecting historic heritage, responding to housing challenges, natural hazards, about where the balance should lie. The material that Dr. Kerr and Ms. Cutton have produced has a lengthy critique from a public policy perspective of the rigor or lack thereof of the council's weighing of costs and benefits. In this context, we're at a general level. What's your general response?
My response would be the level of analysis in the Historic Heritage Section 32 is consistent with that incorporated by other councils. And developing new historic heritage provisions and including new places on their list. In that, Section 32 allows us to group provisions for assessment, group them by intent, and undertake an assessment at that scale. And that it accepts that it might not be reasonable or achievable in every instance to identify down to the dollar value for every place what the level of effect of provisions will be, but more general commentary is accepted.
Dr. Kerr's response is likely to be that councils generally have very poor processes from a public policy perspective and are, how do they put it, institutionally biased in favour of protection because of the difficulty in quantifying the costs. I think partly also because it's the argument goes that of course the costs of protection are borne privately and the benefits are enjoyed publicly. What's your response to that general philosophical point?
My response would be this is where my comment in my introduction about a continued and conspicuous absence of central government direction rings home.
Is that another way of saying if government didn't like what councils were doing, it's had 30 years to do something about it?
To some extent, perhaps.
Mr. McCutcheon. We have heard a lot and you have referred a lot to the database that exists within council with over 600 potential buildings. You're saying that that has been around basically since 2013. What's the process within council to actually drill down on those 600 properties to do what the RMA asks the council to do, to protect heritage, not just the heritage that has been identified in 2012, but also the heritage that has actually been found to most likely have value over the years? What's the process and what has been done so far?
So the database of around 600 candidates or potential candidates was compiled through nominations from members of the community, from interest groups, from practitioners and professionals of places that may meet the criteria for listing, or that may have heritage values that warrant further research to determine whether they are significant or not. Council will never be in a position to know of every single place that may or may not meet the criteria for listing, and that to some extent it is reliant on the community to raise awareness of these places and to inform it of places that have or are likely to have significant values. The other side of it is what resources are available to determine whether these places have values that are significant in terms of the regional policy statement, and undertake assessments to determine that. Those detailed heritage evaluations for new listings which have had submissions on them, they're available online on our Stream 3 webpage. And it takes professionals like a Smith and people in the heritage field a lot of time to do those reports and those assessments, and there's only a limited number of people who are qualified to undertake them. I couldn't undertake one, for example, and demonstrate that a place met the criteria for listing. So it's therefore necessary to come up with an approach to identify which of those places should have resource allocated to them to determine whether they meet the criteria for listing. And again, I say this is all in the context of the only direction we have is from policy 21 really of the RPS, which says here's the type of places which could meet the criteria for listing. Doesn't say anything further about you should identify more of this type or less of this type. It doesn't do that. So to inform which places went through for further assessment, we relied upon, the evaluation relied upon a 2013 document, the thematic review of Wellington's heritage, in part. And what this review was an assessment of what are the themes and stories of Wellington City, and sort of codified them into, one might be about governance and civic places, or about settler migration, or immigration, or war buildings, or something like that. So that was but one lens which was able to be used to inform this sort of funneling down of 600 candidates down to however many.
I understand that process, but my question was, what has been done since 2013 to drill down on that? Because it seems from the description and the methodology that has been applied to this process now, that there is a gap between when work started happening on that and the 2013 birth of that immensely comprehensive list.
Yeah. So
the question is, what has been happening in the meantime?
Yeah.
Was that just sitting there waiting?
So it's the work like the 2017 Mount Victoria report, which took that look at Mount Victoria and which areas might be eligible for further research, and that's been one of the key inputs that Ms. Smith in her rebuttal talks to the Mount Victoria North Townscape precinct, and how we have a good evidence base that says that whole area doesn't meet the criteria for listing. Other ways in which the council has tried to understand where there may be other heritage places is through work like the Becker Outer Suburbs report, the Outer Suburbs Evaluation Report. So you would have heard about that in stream 2, where Mr. Patterson spoke about that centres-based growth approach. Part of that also looked at possible heritage places. They went all into the same bucket of nominations through which those workshops occurred. But as for, are there places in Johnsonville, back blocks of Johnsonville, or
it's more like what has been done to get those 600 places assessed.
Yeah. So that is the work that not all 600 have been assessed. That my explanation of the thematic review says that is not possible. So they have to be rationalised, and that's the diagram on page 23 in the process which I've spoken to. Ms. Smith, would you like to add to that?
Could I just add a little bit? The database is the place that the heritage advisors go to for information about the place. So somebody might ring in and say, I've seen something, or something might come to light in a resource consent. And unless we've got a database, there's no way that we know that we've assessed it. We don't know anything about it. So it's kind of a dumping ground for stuff we know. When we actually did drill down into it as part of the workshop process, we found that of the 600 things, probably about 100 things were what you would start to look at in terms of something that you think that would possibly meet the criteria. Yep. And we came up with about 50, absolutely, yep. And we come up with about 40, don't know enough. So I wouldn't say it's our wish list, the council's wish list for what it wants to list. It's more a place to put things while you understand about them. And then in terms of what actually has happened, in my evidence, I've put together a list of every step that's happened.
Yes, I understand that, yeah.
Yeah, so basically the nub of it is that after the changes to the RMA in 2004, there was quite a lot of work to identify heritage places in Wellington. And so there was identification of things like shopping centre heritage areas, and there was a push to look at things that have been missed off the operative plan at the time that the RMA changed. And then there's been dates when there's been plan changes. Really nothing significant since 73. Yeah. So nothing. So in the 10 years that I was associated with the council, nothing in that time. But in that time, we did have the Christchurch earthquakes, and so we were. There was a lot of concern about what to do with the earthquake-prone buildings, and there were changes to the Building Act. So it was a really uncertain time after Christchurch for Wellington, and I think we're, probably back in the space where you can consider a list that's growing. Does that? I'll pass you back to Adam, but that's my background.
No, that answered the question. Thank you. With regards to the methodology that you have in your paragraph 96, the table that has been provided, in terms of prioritising the buildings that need to be on that list, and it's completely understandable that there needs to be a priority on things. One of the clear things that stood out were the buildings that are registered or listed by Heritage New Zealand. Now, I'm wondering if one doesn't have lots of resources, what is the rationale not to believe and rely on research and work that has been done by our national protection agency, if you want, instead of just taking them in as, okay, they have been assessed, they do have, because otherwise they would not be on the list.
If I can, I'll speak to that quickly. Some of the items that were listed by Heritage New Zealand were quite old, and the listings reports that they had, I don't know why, because I wasn't at council at the time the decision was made not to list them, but they had been on Heritage New Zealand's list for a long time. And those items actually needed a reassessment and a lot of research to bring the reports up to the current, what Heritage New Zealand would expect to do in those circumstances. Where Heritage New Zealand has written a current listings report, when I write the council's report, I tend to go to Heritage New Zealand and ask that whether I can adopt their report, substantially adopt it. They prefer that the reports are either adopted as a whole, or that you're very clear where you're making a comment that they don't. But in those circumstances, yes. I didn't write many of the reports, so it was down to the consultants. But yes, that the Heritage New Zealand reports are the gold standard, and where they can be adopted, they should be. And then the last thing is that Heritage New Zealand use slightly different assessments criterion, because their act has a slightly different definition of heritage. And so I think that we should be following the regional policy statement, which drops down from the RMA, and the exact wording of their criteria is slightly different from Heritage New Zealand's. And Heritage New Zealand's asking us, in their assessment, is asking whether it should be a category 1 or category 2. Our assessments aren't doing that. So really, I think substantially you can adopt Heritage New Zealand's reports. They are the gold standard. The preference would be to do a double check against the RPS criteria, but they are so close that if Heritage New Zealand says significant, it will land as significant under the RPS criteria. Does that answer
that answers the question, but it also brings up the next question. I understand that the RPS section 21 has slightly different assessment criteria, but in the lack of time and resources that is there, I think some of the submitters were quite surprised that the resources that were allocated were then allocated to do a job a second time, just to tick off a little box that is somewhere to make it look better, knowing that the outcome is exactly the same.
So just to clarify further to Ms. Smith's point, that where those reports did exist, then that information was relied upon. I suspect where we're getting to is in relation to submissions to add from Heritage New Zealand to add places like Hurston that are on their list but not on ours. So as I've explained in my 42A report, the reason why they haven't been included to date is because they were added to Heritage New Zealand's list partway during our process on the draft district plan, where we had already made contact with owners of buildings that we were proposing to add onto their schedules and consult with them in good faith about what this might mean. So the timing didn't align. What I've said in my 42 is that it's kind of up to you guys whether you think it's appropriate, and that people have had a reasonable opportunity to notice a submission on the plan and take the chance to lodge a further submission either in support or opposition to it. But that's not the same level of opportunity that all other proposed new listing owners have had. They've had more. So I have not seen it as an equitable opportunity for people to be informed and have an open and transparent discussion about what that might mean, which is why I haven't recommended those places which have come in through this process, even if they are listed by Heritage New Zealand, which there are totally a few of them.
Yeah.
That's why I haven't recommended they be added. But you can take different approaches. Council gets critiqued for not doing enough engagement, even when we do it. It's sort of up to you whether you think that's appropriate or not, I've stated my view.
Just in terms of the numbers that you gave us, Ms. Smith, about 40 that were a definite yes, and about a 50 that were maybe. 40 and 50. 50 were a yes and 40 were a maybe. How many of those in each category were buildings that were already listed with HPT?
So the numbers are in Mr. McCutcheon's evidence paragraph 96, and I've taken those numbers off the table. So we had 7 category 1 listed, we had 7 category 2 listed, and we had 8 heritage areas.
8 heritage areas. So they were part of the 50 yes, is that correct?
No, what I did was before we held the workshops, I found the Heritage New Zealand listings and I put them to one side because they were definitely something that we were going to look towards adding to the district plan. So I used the database to do the triage of saying, right, this is Heritage New Zealand listing. I contacted Heritage New Zealand and said, what's your current nominations? What are you working on at the moment to work out what might come through in that period? So each section onto the, sorry, I'm not very good left and right, but to the left under sources, each of those is kind of a separate set of numbers. Yeah.
So in effect, those we have 22 places are in addition to the 50 yes and the 40 maybes. Was that how I understand it?
That's my recollection of it, but it was 3 years ago now. So I am relying on memory for that one. But we can go back to the records of that.
Yeah, I just tried to get an understanding of how much how much resources are needed to actually get to a certain point, particularly since there is so many submitters that saying it's not enough. Okay, no, we'll leave it at that. Thank you.
Just before we go off that section, which is the thematic review and prioritisation, just a couple of questions from me. Thank you for that process diagram, Ms. Smith and Mr. McCutcheon. I found that useful. It would be even more useful if you could put some dates into it, going from left to right. And on the right, we end up on the situation in June 2020. But I'm not sure when the Becker report, the Boffin report, I think he's mentioned about Vic Heritage Report was 2017, but some dates for those, and then the dates for the process involving Ian Bowman and Elizabeth Cox, the nominations, the gap analysis, the assessment, and leading up to the June 2020 would be useful in your right of reply. The risk of asking a dumb question, in terms of these 600 candidates, and this whole process, presumably that included listings in the ODP as well.
No, these are
all potentially brand new.
Yep.
Okay. Glad I asked that question. Okay.
How many were already listed in the ODP?
That was my
550 odd. And then there's contributors to heritage areas, which I think total around 300 from memory. I can find those numbers precisely for you pretty quickly.
It would be good.
Yeah.
The next question really is, and you probably covered this somewhere, but I can't find it, is how many weren't carried across from the ODP to the PDP? So was there some that have already been delisted or demolished, and therefore?
Yeah, they definitely were. I can get those numbers quite quickly for you as well. Like 128 Abel Smith Street burned down. There's no need to include that on the list.
Yeah.
And there were some. So all current operative district plan listings had a review to check that they still meet the criteria for listing, and as a result, some did come off because there wasn't the same level of information, or they couldn't be convinced that they still meet the test. So a small number, might have been around 10ish. I'll find the correct number for you, came off.
Probably less important now, given Mr. Whittington's revised response on 77K, but still good to know. Trevor, I've got a couple of big picture questions, but maybe I park those until the end of Mr. McCutcheon's presentation. They sort of touch on the thematic approach, but they go beyond that.
Okay, well let's pick up the detail and see where we land. I got to paragraph 121. Any advance on 121? You said difference in terminology, ongoing use to original use. In what context is the term ongoing use used?
So when talking about how buildings are used, particularly heritage buildings, there's much discussion around adaptive reuse or reuse or continued use, original use. All of these different terms float about. My view is that what is an acceptable use for a building is primarily governed by the zone provisions of the district plan, which say in a residential zone you can't have an industrial use, whereas in a city centre zone you can have a variety of different uses. They're all acceptable uses of land. What was tried to be clarified in the heritage provisions is that what we want is for buildings to have a sustainable long-term use. So whatever that use be, we want it to be in use so it doesn't get neglected, it contributes to a well-functioning urban environment. And that use could be the one that it was originally constructed for. So the woolshed, for example, it could still be used as a woolshed, and that, you know, would have an existing use rise if that were in the city centre zone or whatever. And that would be a good fit for the reason that the building was built and the values that it's managed and protected for. But that use might also change, and you know, to reflect modern ways of the modern economy, and that we don't store wool in the city centre anymore. So it might now be reused and have a different use from what it was originally constructed for, or the original use. And that's used in the introduction to the Heritage Chapter, and the term reuse is identified in a number of key places, including in the policy for total demolition, where people are required to demonstrate how they've considered a different use for a building and why it isn't a viable outcome. And it's also used in a couple of the additions and alterations policies.
Just jump in there. With regards to that use, to that alternative use, is there somewhere in the plan a consideration of if that use is actually compatible with the heritage values of the building?
So the scope of what would a use be appropriate would be addressed within the context of additions and alterations, and if work is being undertaken to support a different use, whether the scale of the alterations or how they were designed were appropriate, but not necessarily that a barber shop is not an appropriate use for a building that once was a wool store. As I've said earlier, my view, in the structure of the plan, the zone rules determine what are the appropriate range of uses within a place. So what we don't have, for example, is if you weren't going to do any additions and alterations to a building, you wouldn't need a resource consent to change a use from a barber shop to a doctor to a bar. Those are all uses which would probably be in the city centre zone permitted under the zone rules. So there's no consent trigger. And our plan is purposefully in areas where we have most of our heritage places, like the city centre and the centre, is very flexible, that a range of different uses are enabled to support places being kept in use.
Just that very old thing that has been in the heritage area for many years. How about we are changing the church to a brothel? How appropriate is that for the heritage values of the place? It has been around forever, but
in the spotted history of Wellington City, I'm sure there's quite a number of.
Well, possibly the other way.
Yeah, I mean, the bar Pop used to be a doctor's surgery on the corner of Willow Street. Now it's a bar, and it's somewhat ironic as well, isn't it? But there are other mechanisms in place to determine whether that's an appropriate outcome, and the actual effects of amenity values, or whatever the effects of such an institution might be.
Well, I've got a wider question, and that is, what does it matter?
Mm.
What does this definition go to? Does it go to a policy, a rule, a standard?
So the chapter does recognise, and I do recognise as well, that the original use of a place and why it was built can be in part a reason why a place has heritage values. You know, it was the first building built for storing wool within the city centre, therefore it has significance to that extent. But the plan provisions don't try and curtail a change of use, and I'm going to offer Ms. Smith the opportunity to speak as well.
Specifically, an example. I was looking at a resource consent that had come in for a play centre, and the play centre had occupied the building for 50 years, and the rules for early childhood facilities had changed, and they absolutely needed a place to change children in a specific way, and there was absolutely no way that you could fit it into this little building. So as someone who was doing the assessment of that, my view was that actually you could kick Play Centre out of that building and say, tough luck, it's a really important building. There's nothing you can do to it, loves, just go off and find another building. Or you could say that Play Centre actually has a really strong connection to this building. It wasn't built for them, but they've occupied it for 50 years from the beginning of the Play Centre, whatever. And there's a really good reason for them to make this adaptation to continue that use, which I thought was part of the intangible heritage of the place.
I understand all that.
Yep.
The question is, where is this term used in the plan?
So original use, let me just pull out the provisions to help draw your attention to the specific places. So the concept of sustainable long-term uses in policy P5 in the introduction talks to how a long-term use could be of any uses. The same phrase is used in P7, additions and alterations. And the term...
So these are the I'm struggling to see it in P5.
Oh, so the that's in the second clause of recommended P5, supporting providing a sustainable long-term use. And as of in the introduction, it talks to how that could be both reuse and original use. And in recommended P11, which talks to including to enable reuse. So what the intent of addressing these terms head on is to send a signal that it is appropriate that places change uses, and that is not necessarily a bad thing. All that the plan is trying to regulate is the extent to which you might need to do any additions and alterations to that place to enable that change of use and its functionality, as Ms. Smith has outlined, and you know, the extent to which those works are of a compatible scale or form or design with the heritage values that are trying to be managed. So it's really trying to tackle this issue head on, where there's a lot of noise around places should be reused, and absolutely that's what this plan is trying to support if a use needs to change within a building.
Thank you.
Up to 146.
Question to for maintenance and repair. In 126, with regards to your structural elements under surface treatment, D, you are trying to clarify what is meant by surface treatment. And you have two examples there. One is painting the fabric that is not currently painted. And the other one is recladding wooden weatherboards with aluminium weatherboards. And how far is the change of materials, and basically the weatherboards are part of the structural element of a building as much as the weatherproofing of a building.
Mm.
And how far do you see cladding being the same as paint?
Mm. So in examining this definition of maintenance and repair, I suggest the version we turn our minds to is in paragraph 151 of my rebuttal, which is my latest recommendation. In terms of your specific question,
Hold on till I retrieve that.
Cool. So the specific question, would a building that is currently clad in wood, could you replace that cladding with aluminium or corrugated iron as a permitted activity under the repair of definition and maintenance? And the intention is no, because that is changing the design, texture and form of the fabric. So that's clause E. And it also doesn't use the materials the same as the original or most significant fabric or the closest equivalent. So what this is trying to do is enable people to repair and maintain their building, keep it in a sound weather-tight condition, but setting thresholds by which you wouldn't trigger the additions and alterations rule. So like-for-like replacement is essentially what we're looking for, or like for closest equivalent. So that's why I've recommended so clarifying that, painting anything that's not painted at the moment or rendering anything that's not rendering would not be considered maintenance and repair, and it would accordingly trip into an additions and alterations rule, because that's not maintaining or repairing the status quo essentially.
And it's all a permitted activity, isn't it?
Correct.
So how do you ensure that the heritage values are protected when one of the important mechanisms of heritage protection is authenticity and integrity of the building? If you have actually somebody maintaining their house all the way around, piece by piece, and you end up with having nothing left of the original, what's the heritage value then? You've lost it, haven't you?
So this definition needs to straddle a fine balance and find a balance of enabling people to do works that ensure their building does not degrade, and to fix things that are wrong with it, with a reasonable level of certainty that it won't be done in a way that adversely affects heritage values. And it's always going to be, there's going to be a degree of risk in any permitted activity that something will be done not quite the way that it was envisaged. In that case, the levers council has, or the opportunities that owners have, is through conversations with council's heritage advisors or seeking heritage advice before they undertake repairs and maintenance, to be satisfied that they would be meeting the permitted activity standards, to know what pressure they should use their water blaster on so that they're not blowing bricks apart or driving water further into a structure when it's not supposed to. So there's an element of sort of personal responsibility there on people to come and seek advice. I've considered, should any works be controlled? That's the ultimate way in which council could ensure that there would be limits on any works to heritage buildings, but I don't consider that appropriate for works to repair and maintain places, and that we should be reducing those barriers for people. So rounding back on your question, yes, there always is a degree of risk. I've tried to ensure that there are enough triggers or standards within this definition that wouldn't enable people to cumulatively degrade heritage values. But ultimately, if people do that, the only mechanism really is enforcement. Yeah, sure.
Sorry, but I've literally been involved in something that was what you're saying, where the builders interpreted repair and maintenance to the point where the building disappeared, and the compliance officer came up to site and found there was no building there. It was dealt with through compliance, because clearly repair and maintenance is making good decayed, or the A and B, I think, are the things that set you up for that. So in that circumstance, I think A and B would have directed the compliance officer to go, well, is the entire loss of the building repair and maintenance? It doesn't seem to be to me. I don't know if that helps in any way.
Would you think, in your capacity, not as a planner but as a heritage person, that the plan needs to be a little bit tighter on that, even if it is permitted, but and we know that there is a risk is there any way of plugging that hole with, I don't know, further policy, further rule?
It's really difficult because if you add too much detail to the repairs and maintenance, then you forget to add something specific. And if you don't add enough information to it, then the compliance officer who goes to site or the planner who's making the decision doesn't actually have enough direction to make a call on it. And it's often you'll have the conversation with the planner or the compliance officer, but it's their call and you have to persuade them based on what's in here. And so what Adam's tried to do is to work out what the things were that were problematic and needed clarification for that communication, even within the organisation, and then that communication to people using the plan. And the answer is I don't know the answer. We certainly talked to Auckland. We had a direct conversation with Auckland, which had a very clear policy. Did we talk to Christchurch about this one? We talked to several councils and just tried to find what to do, and this is what we've come up with. I don't know the answer.
So like in responding to Mr. Leary for Wharenui Apartments, where concerns were raised about the damage of fabric from the use of abrasive high pressure cleaning methods. You know, Ms. Smith has a big table of all the different types of water pressure and different substrates and what would damage them, but I don't think it's effective to put that in a definition of repair and maintenance as a standard in the district plan, knowing that, you know, every substrate is different. And the real opportunity for people to ensure that they don't damage fabric is through seeking heritage advice. And I think the majority of people will do the right thing, but there will always be people who think, yeah, so it'll get my petrol powered water blaster out and clean these weatherboards. And unfortunately, probably enforcement action is the only way that there's an end to that.
Is that maybe something that needs to be added into that policy, that you do need to seek advice before you do anything?
Certainly there are heritage advice notes that we put in the chapter, and there's quite a lot of there is promotion of the services and the support that council can offer, including in a non-regulatory sense. Yeah, it's the difficulty on it, because if you take the purist view that you shouldn't have a policy that you don't actually implement within the district plan, then it shouldn't be in there at all. So this is kind of the same one. You know, if it's actually implementing it through a non-statutory method, you don't have a loaner policy or loaner provision that doesn't do anything. And that's one of the reasons why we haven't included a general support heritage building owners to do X, Y, and Z sort of provision.
Okay. Thank you.
To 146. 146B. So you agree heritage areas do not always have a continuity of buildings and structures and are interspersed with non-heritage buildings and structures. Should they have a continuity? Like you're going to the, well, what do we call the heritage area? And to what extent do we accept exceptions that erode the heritage values of the broader area?
Couple of parts to my response. So as I had always interpreted it, continuity was to do with like a similarity of a visual form, appearance and design. And so that is true for some of our heritage areas to a large extent, like Tarakaka Street Heritage Area, commonality, a group of railway cottages that are all very similar. Compare that though to say the Parliamentary Precinct Heritage Area, where we have quite different range of styles of buildings within that area, made of different materials, different composition, different form, Same sort of thing with Cuba Street. We've got iterative growth and change and replacement of building stock, but collectively there's definitely a set of heritage values for that place, but the individual components and contributors might read differently or be presented differently. On the point of is there sort of like a threshold or a number of non-heritage things or detractors that would make it not worth having a heritage area at all? The heritage areas that are in the plan and that were part of the review process we spoke to earlier do largely have a concentration of contributing buildings, so buildings which contribute positively. And there are provisions in the plan that permit the demolition of non-heritage ones. So where there are things that don't make a contribution, well, let's see to them that there's an enabling framework for them to be removed and then replaced with buildings that do contribute more positively, or at least are in more fitting in with the heritage values that we're managing through the provisions in the plan. Ms. Smith?
Oh, I was just thinking that it's really what's the underlying point of the heritage area? Why was it listed? And some of them are listed because of their historic association between the things on the site. Like we have a patent slip, and we have a gold mine, and we have things where the things are associated because of their history and their use. And then we have rows of near identical houses. And the question is how, we're not just using the heritage areas to address attractive groups of houses. We're actually trying to look at the history on why something might be connected to something else. And so continuity I agree, the continuity may work really well for Edwardian and Victorian houses. It may not work so well for something that is more intangible in terms of the historic associations of something.
The point G, Mr. McCutcheon, on the following page 39, 6G, the focus of assessment and works on contributory building is on the impacts of heritage area as a whole, not solely on the building. You said is on. Is that is or should be? Given that this whole thing is sort of a constructed concept, doesn't have any immutable correctness. You choose a methodology you believe to be sound. That doesn't mean there aren't other methodologies that wouldn't be equally sound.
The intent of the district plan, or the PDP, is that it should be on the values of the heritage area. Just
by looking at the heritage area as a whole, you're saying earlier in D that you do not agree that contributing buildings in heritage areas should be treated as the same as individual scheduled buildings. Now, if we look at the heritage buildings as an entity of something that conveys heritage value, and we look at the heritage area as an entity that actually does basically the same, just on a different level. If I can't make changes to the individual building because I might actually disturb the heritage value or reduce the heritage value, you are saying, but you can disturb things within the heritage area because the buildings as such are not treated the same. Explain that to me, please.
Sure. So for both additions and alterations to a heritage building and to contributing buildings within heritage areas, they both have restricted discretionary activity status. Need a resource consent. that resource consent may be refused if the effects on for the heritage building, the values of that building, as identified in the very detailed assessment we have for that place, are not acceptable. For heritage areas, it's about undertaking that assessment of heritage effects on the values of the area as a whole, recognising that the reason the area is listed in the plan is because the area as a whole, comprised of buildings that contribute to a different extent, meets the criteria for listing under the regional policy statement. So the assessment sort of steps up a level that says, right, if we made a change to this building here, collectively, what's the level of impact on the values of the heritage area as a whole?
So you're saying at the end of the day, they are sort of treated the same because it's both restricted to discretionary if anything is done to them.
They're the same level of activity status, absolutely. It's just the assessment, the focus of the assessment is different. It's broader in scale than just than that on the specific contributing building, but on the values of the heritage area as a whole.
Thank you.
The going to page 40, paragraph 150. I was intrigued in B, you suggested addition. Any related resource consent assessment. What does related mean in that context? Is it even required?
On reflection, related probably could be removed. I don't think anything it adds anything. If you need a resource consent, you need a resource consent for works to heritage buildings.
Next, further down, discussion of heritage areas, used to be C, for the avoidance of doubt. Should that be works to buildings or works on buildings?
The terminology used elsewhere throughout the chapter is works to, but equally you could say works on. I prefer the terminology works to because it's more sort of active language in my mind.
Bottom of the page, having asked you where this term was used, you see this is where you swap from ongoing to original. Should you say something a little more rather so than the original use can be a sustainable long-term use? Should you make that projection in the future? Say something like continuation of the original use.
I think it is valuable to read this in the context of the whole introduction, where it starts off saying under the sustainable long-term use heading, one of the best ways to protect the recognised heritage values of built heritage is to ensure that it remains in a sustainable long-term use. The original use of a building can be part of the reason why it is important and helps retain special associations between people and place. And then the remainder of that sentence, that paragraph down through the one in the Rec 14 helps.
So your point, it makes sense in the context
Yeah.
of reading.
If I could just add to that, I wonder in light of that explanation and given the move away from ongoing to both original and any future, whether the and should be an or at least an and or in that first line.
Wellington's the expert on ands and ors. my memory.
Well, the intention,
Yeah. The
is
intention
to recognise both the original and the longer future, so or might be
all would be acceptable
more
too.
appropriate.
Yeah.
Yeah. Thank you. Will you reflect those changes in your right of reply?
I can do.
Yeah, that would be good.
Same sentence. Carefully done partial demolition. Should that be managed? Or some other term? Carefully done seems a bit odd. Maybe that's just my eye.
The reason that carefully done is inserted there.
I understand the need for care,
Mm.
but it's the done that I'm interested in.
Undertaken.
Some other done, as I done seems doesn't quite fit. Managed.
Mhm.
Robert,
165. Good choice. I'm with 166, Commissioner.
Greater Wellington sought in 165 the inclusion of accidental discovery protocol, and in your assessment at para 183 on page 47, I'm kind of not sure what it is you're actually suggesting in there, because you finish with saying the placement of this notice in the resource consent is also standard practice. So are you agreeing with it being included as, are you agreeing with an accidental discovery protocol being included, or are you saying it's not necessary because it's standard practice?
Thank you for pointing that out. I am in effect saying it's not necessary because there's already a reference to Appendix 1, Historic Heritage Advice Notes, which contains reference to the provisions of the Heritage New Zealand Poheri Tonga Act to protect archaeological sites. That's in the introduction to the Historic Heritage chapter. That appendix contains all that detail about what to do if you find koiwi or taonga tututu when you're undertaking works. And then in addition, in terms of the notices, so it's standard practice that a notice is placed on a resource consent that reiterates that message. If you put a spade in the ground and you find something, this is what you need to do. So I think it's unlikely that people will ever not know about this unless they're willfully ignorant.
So if you're going through a process of getting an archaeological authority anyway, what would you lose by including as part of that? I don't understand why one is a requirement, but we don't see the need for the other to be as such for certain areas.
So let me start with these rules, primarily dealing with works to heritage buildings. Some may be pre-1900. Yeah, and in that case, they would need an archaeological authority from Heritage New Zealand. The Earthworks chapter does contain that reference to the accidental discovery protocol.
Yeah. That's cool. Yeah, thank you. That's cleared that up.
Question about how 166 discussing facadism. You said that policy 7 supplemented by guideline in the Heritage Design Guide provides direction about the nature and extent of works proposed where demolition is sought behind the facade. I have a more general question about what is the what is the rule status if only parts of a building have been scheduled to a proposal to demolish the unlisted parts?
So where parts of a building are scheduled, but not the entire external envelope, these are identified in Schedule 1. The demolition of the non-scheduled bit would not be managed by the historic heritage provisions, provided you didn't touch or modify the actual scheduled part. In reviewing the operative district plan heritage list, an assessment was undertaken to determine if any of the partial listings, which we do have in the operative district plan, there aren't that many of them, but if any of them could be amended so that the entire external building envelope would be subject to the heritage rules, because on reflection, the whole structure would meet the criteria for listing. So I think there are only a couple that fell into the bucket, but largely the ones that have partly scheduled exteriors is because the remainder of the building is completely new by the time it came around to scheduling. So your answer to the question is they would not be subject when you're not touching the bit that is scheduled.
So we had Sabita saying with regards to partially scheduled, for example, the addition on top, I think it was Willis Bond, it wasn't Argosy.
Top of the old state insurance building in Lambert Key.
So it's only the bottom that is actually scheduled, but there is, of course, an impact, whatever happens on the top, on the values of the bottom. So you're not scheduling it, but how are you protecting that then to make sure that there is no inappropriate development going on?
I think in that particular example, the addition is scheduled, and the argument was whether it should be
out. Yeah.
Whether it should be unscheduled.
You know, it's
I'll respond first with just a plan mechanics thing, and then Ms. Smith will answer. In the mechanics of the plan, within those zone chapters, so in this case, the city centre zone, the rules and the policy direction for achieving quality design outcomes and building a building or altering a building requires an assessment of how that new development responds to adjacent heritage listed buildings and structures and sites of significance. So that would be a trigger there for some degree of discretion through the resource consent process, albeit through the rules triggered in the city centre zone chapter, to consider the effects on the scheduled part of a building.
So when I was at council, I went through every single partial listing in the ODP, and I can't find the document because I filed it somewhere very safe when I left the organisation. But there were certain circumstances that the partial listings fell into. Some of them were very old listings from the 1990s, just before the plan became operative, and that was before the RMA got Section 6 came into the RMA in about 2004. Adam, you're the planner. So there were some very old listings. We worked out that a lot of the partial listings were in heritage areas where the heritage area rule applied to the rest of the extent of the building. Some of the partial listings have been handed down as a legacy from the Environment Court, and we didn't want to unpack those because a lot of work had gone into getting the listing to the extent that we had it. So there's a kind of a mixed bag of what we've got, and some things were just a slither of a building that was left after the partial listing had done its job, in fact, and that the building behind it disappeared, and we proposed to remove the listing of at least one of those because the worst thing that could happen to that building had happened. They're not great, but it's a bit of a legacy. We've gone through them one by one from memory, and we did what we could to propose ones where we could see there was a point in expanding the listing, and I'm not sure we actually got to the point where we found many of those.
Recommended Rule 27 is an example of how one of the court settled partial listings has been implemented within the plan.
With regards to you saying, oh, yeah, it's a sliver, and we has been either by the Environment Court or because it has been an old legacy scheduling, we couldn't do much about it. Mr. McCutcheon says that he agrees with the submitter that in some instances the facadism is not appropriate, or in some instances when it's poorly executed, it can have a detrimental effect on the heritage values. Now, doesn't that actually, allowing facadism, does that not create more of those instances where partial things are only scheduled, and how much value, how much heritage value is in a facade?
So the intent of policy P7, and it's a reasonably tough test that you need to demonstrate that work does not detract from identified heritage values, has the intent of putting a really high degree of scrutiny on proposals that are proposing just to leave a slither of a building. So what the considerations that are examined in P7 are, the extent to which you remove heritage fabric. Does it retain the main determinants of the style? Have you minimised the loss of fabric and craftsmanship? So just demolishing the entire rear of a building and not retaining any understanding of the form and function of spaces behind windows, the original layout and composition is not an outcome that would be taken lightly through the resource consent process, and one where heritage advisors and the planners have the scope to push back on. I think Ms. Smith and I spoke about this yesterday, and we're both of the agreement that it's only in sort of reasonably last case scenarios for additions and alterations that facadism is an acceptable outcome, and that always in the first instance you're looking to retain more rather than less heritage fabric in redevelopment proposals. And as the design guide shows, an understanding of what took place within, behind facades, there's a sense of room, there's a sense of depth, and the design guide talks to how greater depth might be useful to retain some of that, that understanding of the function of a building. Because what it's trying to do is avoid situations like Hamilton Chambers on Lambton Quay, which is now being delisted because it's literally a skin of a building in front of a car park. I think it is on the inside of it. But a lot of proposals will seek to remove an element of fabric, to the rear of the building, and it's about what level of fabric removal was acceptable within the needs to achieve a sustainable long-term use within the context of Policy 7.
So facadism for you does not mean the facade, as it actually literally means. It means the facade and something else behind that.
Well, I think it means something else behind that as well, because in my view, if you're demolishing the rear end of a building, but you've still got front half and a depth of 8 metres or something like that, you could perhaps still consider that facadism, that there's not a lot of building behind it, but that is still a better outcome than just the skin of a building that deep and a brand new thing behind it, because you've still got that sense of what was the function and form of the interior.
But does that actually protect the heritage values of that building?
Well,
or
it'll be different.
Then better to say, okay, there's no use other than keeping the slither at the front, and that would be better to be demolished into.
I think it'll depend on the individual circumstance of the building and its its condition, how much of it has to be removed to make, in a development proposal. But typically, my understanding in conservation planning anyway is that the less stuff you can remove, the better. And you don't want to typically make it easy for people to remove all of the stuff, such that you could argue, well, there's no point in keeping any of it at all.
No, but as Wellington heritage professionals have actually pointed out, there is also a certain quantity that needs to stay for a heritage value to be carried, and if that is not there, then what's the point?
Yeah, and I think that the Heritage New Zealand guideline that used to be on their website on partial demolition is very useful, and it said things like, don't do it. If you have to do it, is your building damaged? Is there something happened to it? Is there something that's very low value? It's quite difficult to turn that Heritage New Zealand guideline into a policy, and it's actually much harder now they've taken it off their website.
Why that happened?
But I think the problem that I see practically from implementing it is as soon as you put something like that put the Heritage New Zealand guideline into the district plan, it becomes the baseline of the resource consents from now on, and people will go, oh, they only want the front room now, right? Oh, well, we can do that. So I don't know what the balance is on facadism. It's really difficult.
The question is just plainly, as Wellington heritage professionals have pointed out, what's the point of the facade? Rip the whole thing down. Why do we have that in the first place? It doesn't, from their point of view, it doesn't make sense.
Yep, and I'd agree with them. Yep.
Something to think about.
That's happy note. Agreement. We'll take our lunch break. Back in 50 minutes. 1:30.
just got the photos. It doesn't look good.
Continuing the hearing, stream 3, Mr. McCutcheon, can I take you to your suggested policy at 185. This is about the extent to which it attempts to anticipate demolition by neglect. And my reaction reading this is that it's all a bit subtle. I don't know what it means. It's not actually telling me what the policy direction you're seeking to apply is. Saying there's no reasonable alternatives, including maintenance and repair. Yeah, understand that. Maintenance and repair is an option, including the extent to which this has been regulatory undertaken. I read that and think, so what? And I wonder whether it would be more understandable if you put it in the negative. So something like maintenance repair, considering in particular the extent to which it has not regularly been undertaken.
I don't think it would make a substantial difference, but
In other words, my wording is no clearer than this. Is there a way in which you could actually say what you mean? Because I don't think this says it at the moment.
so how it relates to the relevant rule, which is recommended R13, is that R13 requires applications for total demolition to include information detailing the history of regular maintenance and repair undertaken on the building or structure.
Yes.
I think I'm looking at it in the positive way, assuming that people have done works, and some people, of course, will not. I guess it depends how you want to look at it. You can assume the negative.
I'm thinking about the acute lawyer who wants to find a way to evade the intent of the policy and who says that the policy direction is meaningless.
Mm.
That I think that what you're saying is that if maintenance works have not been regularly undertaken, that is a reason why maintenance and repair might be a reasonable alternative when otherwise that might not be the case. I think that's what you mean, but it doesn't say that.
Yeah, so in my 42A from para 172 onwards, what I say is that I'm looking for the deferral of maintenance and any money saved by doing so to be factored into that equation of whether there are any reasonable alternatives, because you'd say, oh, well, you might have saved $100,000 by not doing maintenance to the building, and that should be considered in the viability of determining whether it should be demolished or not.
Yes, I understand that.
Yeah.
My problem is that I don't think the policy says that.
Mm.
It's sort of dancing around a little bit on a pinhead.
Yeah.
Because, I mean, you obviously don't want to use the words demolition by neglect.
Yeah.
And you're trying to find a surrogate for that in a way. I understand the issue.
Yeah, in the 42, I talk about how we're operating in a pretty big vacuum here around what we can actually do in a district plan, knowing that no one else has really tackled this either. And so,
like I suppose that I understand all of those things.
Yeah.
But to me, that means that there's an onus on being really clear what you do mean, because precisely because there's no precedent, if it's in any way ambiguous, somebody's going to drive a truck through it.
Isn't the issue though with a form of wording that's expressed in the negative that it excludes the positive? So the point, and I think the reason it comes across as potentially a little vague, is because it is intended to capture situations where through deferring maintenance, a person has saved money that should be factored into the equation. But equally, if somebody has and can demonstrate that they have undertaken regular and routine maintenance for a number of years, but it is still simply not viable, or the other options are not viable, then that should be taken into account too.
That might well be right as well, Mr. Wellington. The issue is none of that is conveyed to me by this policy wording. None of those nuances, and maybe all we can do is suggest that Mr. McCutcheon put his thinking cap on as to how that basically one line could be reframed to more clearly capture what's intended. Because as I say, it doesn't do it for me at the moment.
And if you're doing that, I think you're going to have a consideration to the attendant rule at R13, where there's sets out the information requirements that must accompany the application. And the very first one that you've added and read is the information detailing the history of regular maintenance and repair undertaken on the building or structure. So clearly, clause 1 speaks to policy, the LIM policy 1, LIM and piece 11. But if you change one, you might have to change the other.
Well, it doesn't need to say something like, take Mr. Wellington's point, maintenance and repair, including consideration as to the extent to which maintenance and repair is a reasonable option, having regard to, like that's a huge mouthful, but that's the concept I think that you're talking about. But none of that comes through.
Through you, Mr. Chair, that wasn't the concept that I was. I thought I think that's possibly dealt with in the information requirements, clause 4 on. But I thought the concept in clause 1 was, has the maintenance been deferred such as to produce a result that leaves no other option other than demolition?
Yeah. Like we're all going around in slow circles because the policy doesn't tell us what it means. So I think that I've given you some alternatives.
Yes.
Mr. Whittington's told me a good reason why one of them doesn't fly, but I don't think, well, calling a spade, this really doesn't do it for me because it doesn't tell me, like the fact that the Commissioner had a completely different interpretation to what I did.
Presumably then the alternative offered by WCCT doesn't do it for you as well. So what they've recommended is striking through including and changing it to taking into account the extent to which this has been regularly undertaken.
No, because that still omits the fact that it's taking it into account how, why. To me, it's because it goes to the reasonableness of that of repair and maintenance as an option, but it doesn't say that.
Yes, yeah. Whereas I read it in the past tense, and the Chairman's reading it in the future tense, I think. Well, like which it might be an option.
Well, yeah. That as well. I think we should just throw it back in your lap with a suggestion. We think it needs more work. Go for it.
Yes, because this isn't talking about repair and maintenance per se. This rule, this policy is dealing with demolition, isn't it?
Well, no, it's dealing with lack of reasonable alternatives. And
Yes.
so the reasonable alternative is repair and maintenance.
Okay.
Or possible repair and maintenance.
Yeah,
So the question is whether that's reasonable.
yes, yeah, okay, I can see why you've landed your interpretation.
But you had a question.
I'd like to go one back to 184. Reading that and having had a look at the Argosy argument to say that they want a rule that actually permits changes to parts of buildings that are not scheduled on a scheduled building. You have actually suggested to say in heritage building, the building or protected parts of a building identified in Schedule 1. Is that really what Argosy meant? It seemed to me more like what they are asking for is permission to change and alter anything on a non-scheduled part of a scheduled building without going through a resource consent process or in the other way, having it as a permitted activity. And I'm not sure that your suggestion to add or protected parts of a building is actually covering that.
I considered adding an additional rule, but I don't think it's necessary given how few partial listings there actually are. Even without this amendment, the rules would function such that you wouldn't need a resource consent when if you were modifying part of a building that wasn't that which was scheduled as a protected part. So if the facade is the only thing that's scheduled, and there's not many of them that fall into that bucket, the rules wouldn't apply anyway for additions and alterations to a heritage building when the protected part is only the facade, if you were doing works at the back of it. So what my amendment is trying to do is to make it clearer that when we're thinking about heritage buildings and the application of the additions and alterations rule, in the event that works are being undertaken to a building that only has a protected part, it's only the protected part that we're interested in. Then by inference, the heritage building rules don't apply to the rest of the building and the zone rules kick in. And I didn't think that it was necessary to have a separate rule that said works to non-protected parts of buildings where there are partial listings, because I thought it wouldn't be beneficial and probably more confusing given that there are not that many partial listings.
But doesn't that go back to the some that we had before, where the bottom part is still there and then the new part has been put on top, but it still is the top part, if that is changed, still has an effect on the heritage values of the bottom. So I don't quite see where we have a clear line that even if you are building on a non-scheduled part of a scheduled building, you still need to take the heritage values of that building into consideration.
Maybe to clarify that, we should go to the rule. What rule would this fall under that you are clarifying? Presumably it's demolition rule.
Yep, rule,
11, I think.
take rule 7. So additions and alterations and partial demolition of heritage buildings and structures. So works to a listed facade above ground floor level. That was the only part of the building that was included on Schedule 1, would be RD. Works to that ground floor would just be subject to the building rules in the city centre zone, because the heritage schedule is essentially written off effects to the part of the building that the facade, that the facade isn't listed on.
What rule did you say it was?
7.
Rule 7.
Right.
Because if you have a partial listing, then you're saying we're only going to apply the heritage rules to that part of the building. The exception, as Ms. Smith has pointed out, is if that building were located within a heritage area, where the heritage area rules also apply to all buildings for additions and alterations, and therefore to the non-scheduled bit of the building that has a partial facade listing.
Well, take us to an example then in the schedules of a building which is only part listed. So you'll see how it's actually described.
Sure. So on page 58 of Schedule 1, item number 468. 32, the terrace, Braemar.
I think that tells me that Argosy and the retirement parties were right, because it, what's the heading? What's the column? What's the heading on that column?
Protection required.
See, that doesn't alter the building that's been it's also inclusory. So the building is 32 the terrace. You're altering 32 the terrace in terms of rule 7, unless you have the amendment to the. So like, to me, at least as it relates to that building, the amendment to definition makes a substantive difference. It certainly provides the clarification submitters were asking for, but I don't think, in terms of interpreting what's currently there, at least as regards this example, it's non-substantive. I think it is substantive, because otherwise, if you were demolishing other than to a depth of 5 metres, but maybe the answer to the Commissioner's issue is that the depth is defined, not just the facade, it's a depth, and presumably that depth is designed to, so you don't have the Hamilton Chambers scenario.
I think in this case, that was a consent order, that one, and it relates to 2 facades. It's there's a bit of legal road that goes down the side, so it's that you just don't have the side that faces the terrace. It's the side that goes down the little alleyway / legal road. I do appreciate there are different ways you can do this. The other way I could have done it was in the rules for additions and alterations to heritage buildings. I could have also titled it additions and alterations to heritage buildings or protected parts of buildings. Another option would have been to do, as one of the submitters asked for, have another rule that said, additions, alterations, and partial demolition to bits of buildings that aren't listed where there is a partial listing. But I also think that would be somewhat confusing given the relationship with the heritage area rules, where if it's within a heritage area, the heritage area rules do actually apply to the rest of the building that isn't specifically listed. So I do acknowledge that there's a little bit of a vacuum there where it sort of slips through the cracks, but it is where it is essentially permitted by the heritage rules, but not perhaps by the zone rules, to modify part of the building that isn't subject to a heritage listing.
Well, going back to where we started, I think that the change to the definition is a more effective way to do what you're trying to do. The issue the Commissioner's perhaps asking is, are you satisfied that where part of buildings is protected, the definition of what is part protected means that demolishing everything from 5.1 metres back wouldn't affect the heritage values of the protected element, because that's the effect of.
Yeah, and that's I think what Argosy is seeking, that they can.
Yeah, and that is what Argosy is seeking.
Mm.
You're clearly responding to the submission, but the question is, does that have collateral effects that we need to know about?
Well, in this case, I would say that where there's a partial listing, and in the case of the exercise we've done to review them, where we say that where we've landed that partial listing is perhaps an undesirable, but the only defendable outcome, we've essentially written off any rest of the works that occur to other parts of the building that aren't heritage listed.
Yeah, but it will still have an effect
Undoubtedly.
on that
Yep.
part that is scheduled.
Yeah, and unless the entire building's listed, there's no way around that.
Otherwise, it might be.
Well, I suppose the point, what you're saying is that it's inherent in listing part of a building that you, quote, don't care, unquote, about what's not listed. That's your policy position where you're coming from.
Yeah, and I noted earlier on in the session today that those zone rules do contain policy direction to respond to adjacent or nearby heritage listed buildings and structures. So there will be an element of leverage there in the resource consent process to demonstrate design outcomes that potentially respond to adjacent or nearby partially listed things. But I don't think we can lose sight that the bigger picture is partial listings aren't ideal, and including a partial listing, we've kind of accepted whatever happens to the rest of the site, and that's why we don't do it often, because it is undesirable. But I think it's disingenuous to then try and claw everything back when we're not listing the entire building. That would be confusing for plan users.
Maybe there's a scope issue, but you could have policy said something like, we're part of the buildings listed, consideration of effects is limited to the effects on the historic heritage values of the part that is listed. As I say, maybe scope issues including that.
Because at the end of the day, and that's goes back to what we discussed just before the break, it doesn't make sense to have that there if it's if you can't protect its heritage values because you are not protecting it by letting happen whatever might happen in the back or on the top or wherever it is. If you think it's gone, then let it go.
And I guess that
Sounds like a song.
I guess that reflects, where we were at in the exercise of reviewing the schedules. It's do we just get rid of the partial listings? Right. But I mean, that's
like to go forward. I wonder if I think the first thing we need is a list of the partial listings.
Yeah.
Because as you say, there are not many of them, so us wading through to find them. And also details of, as you say, the zone rules. What exactly do they say, and what are the policies in them say about protecting adjacent heritage? Because I think what the commissioner's thinking of is whether it'd be better, as I say, to zone the whole building, but have provision that focuses on the historic values of the listed part. But the question, but it may be that what you're telling us is that the provision of the zone chapter gets pretty close to that end result anyway. So it may be like it gets to the same point. But I think we need the building blocks. So the request is a list of partial listings and details of the zone provisions that would apply to those partial listings, because obviously if the partial listings are only in a selected number of zones, then we don't need to know about all the other zones. That, like it's probably fair to indicate there's probably nothing in the open space zone, for instance.
But it would also apply to any partial listings into the future.
Yeah, well, that too. There is that.
And the question there is,
Well,
how much sense does it make?
okay. Good enough?
Yep.
My next one is at page 51, discussing Taranaki Whanui submission. So it's paragraph 212. Can you just explain to us, you said here, better addressed within the SASM chapter and the earthworks chapter. What is the interrelationship between the historic heritage chapter and the SASM chapter? Is there an overlap? Are they like silos?
You get to blame the planning standards now.
What's this?
You get to blame the planning standards now.
Well, that's an easy. That's an easy out.
So they are separate chapters. They share the same strategic direction in the HHSASM, strategic directions for historic heritage and scheduled sites of significance to Māori. But they function essentially as independent chapters. Reason being, when we were working with mana whenua to determine what was the extent of involvement they wanted to see in the district plan provisions and what were their aspirations, they didn't want it to be broader than the sites that they had identified. So what they didn't want to be notified of or made aware of would be works to the Penthouse Cinema in Brooklyn. They don't care. It's not, you shouldn't just assume because it's heritage listed that it has value for mana whenua. That probably isn't the case. So there is a distinction between SASMs and the bespoke rule framework that's in that chapter, which is separate to heritage area building and structure listings in schedules 1 to 3. In the event that those sites do have value for Māori, they may be simultaneously also scheduled as SASMs in that rule framework in the SASM chapter, the one that's used to manage those effects, or it may also be contained within the heritage evaluation reports. But to date, I'm not aware that there are that many. Maybe Fortuna Chapel might be the closest thing that might have some Māori cultural values associated with it, given the architect. And in that case, the values that are contained within that report and described will be used to inform that assessment, but they are largely separate chapters.
Just quickly following up, so you suggested that they're better addressed in those two chapters. Remind me whether that is actually done or not. Is it addressed in those two chapters?
I believe I did. Let me look at my visions.
Because I had a quick look through before, but I couldn't. But it might be. We can address that when we get to that chapter if that's easier.
The intention was definitely to include it.
Yeah.
Going to paragraph 235, this is in the context of visible earthquake strengthening, I think. Internal works, but the examples are of earthquake strengthening. You say changes, you don't think a change to policy 3 is required. Amendments to the related rules and standards are required to implement this recommendation. So I was left thinking, well, if you're relying on altering the rules and standards, what's the policy direction for those altered rules and standards?
I think this is an error because I actually have altered the policy direction in the recommended H8P P4.
Well, that's good.
I'll put that on record.
Uh,
Yeah, there are a cascading number of changes that are needed as a result of my recommendations within this section.
So, well, the answer is I don't need to worry about it because you've altered the policy. Yeah.
In your paragraph 231, you have the view that the visibility of the seismic strengthening contributes to the evolving story of a building's heritage, demonstrating change over time. Now, this is a bold statement, I think. Doesn't that actually apply to any change, whatever happens? How do you distinguish between things that contribute, that are acceptable, and others that are not?
So viewed in the context of the strategic direction of the plan, which asks us to ensure that buildings are resilient, they're retained, and their values are protected, seismic strengthening and works to buildings to ensure that they are resilient and not prone to failure in an earthquake, I think can contribute positively to the story of the heritage values of a place. Ms. Smith talked earlier about how changes of use can also contribute to the values of a place, and how over time they may change, and adds another layer of history to a building and the story of uses that were there. It's, in my view, being able to see strengthening works undertaken is part of the story of increasing resilience of Wellington City. We have, as we all know, some pretty significant seismic issues, but I think on balance it's one that, when we look at the strategic direction of the plan and the controls that I've now recommended in terms of activity status and looking at design and external appearance, the benefits outweigh the costs. I totally recognise this a counter view. We saw that in submissions that particularly the Heritage Professionals Group don't support internal seismic strengthening being visible, but I think we should be looking at reducing barriers while still protecting heritage values, which is where I've ended up in this middle ground option.
Yeah, I was just concerned or curious that this argument, excuse me, this argument actually is an argument that generally applies to any change to anything. You know, and as you say, you put it in context of the seismic strengthening only. But the way it's worded in your paragraph here that's much more open.
I also stress that we can't forget that the heritage provisions, they don't say that any works to a heritage building are good works. They set out a framework for determining whether works will detract from heritage values or not, and where they do, then resource consent shouldn't be granted. So in that way, works that are approved philosophically have met the test for not detracting from heritage values, and should add a layer of heritage and story to that place.
Thank you.
Can we go then to the suggested policy? 248. There's control works internal to heritage buildings, areas that are specifically scheduled, and I'm left to what end? Control for control's sake.
This is one where I think it's been picked up in the might have been Argosy legal submission that I might have created a bit of an inherent sort of gap where I'm not actually trying to control all internal works to buildings to replace bathrooms and toilets and stuff that aren't scheduled, aren't listed separately. I think this probably could do on reflection with a little bit of explanation around sort of controlling new floor levels and seismic strengthening internal to heritage buildings.
But like, as I say, it stops and it doesn't tell me why are you controlling it. What would be relevant to an acceptable work? It just says you're controlling it. Yes.
Yeah.
It's the basis for a rule, obviously.
Yes.
But because all of these rules relate back to it's a one-way operation. It doesn't tell me what the direction underlying the rule is. So accepting that I'm not asking you to draft it on the hoof, but tell me what's the concept in your mind?
Yeah.
How would you decide what were acceptable works in terms of this policy? What would be the sort of considerations you'd bear in mind?
So the only things it's supposed to relate to using the prefix control is the controlled activity rules for new floor levels and internal seismic strengthening that's visible from the exterior. Everything else is intended to be permitted and enabled.
But on what basis would you decide that new floor levels and internal seismic strengthening would or would not be acceptable?
Well, through including a controlled activity status.
No, but yes, that's just telling me you need an application. What's the policy direction as to whether that application is granted, and if so, on what conditions? Well, I suppose the controlled activity has to be granted, but
yes,
but
What are the means?
and well, what is the purpose of the control, and what would decide what were acceptable conditions and what weren't?
the purpose, the matters of control are design and external appearance. So looking at the colour or the visibility of those elements, and the level of modification of heritage fabric. So it's trying to make sure that we're trying to offer in guaranteeing approval of this resource consent. Perhaps there's like a colour that you could paint the bracing element, or it could be positioned in a slightly different way that made it not so prominent and didn't detract so much from the appreciation of that building from the exterior. It's also the scope of submissions on this matter.
Just to say that the Heritage Design Guide addresses some of these issues, but actually doesn't have. So if this went in as a controlled activity, it would actually give a bit more direction to use the Heritage Design Guide for structural strengthening. So that's where I would look to work out what a good look like.
We'll get into the design guide and the roles of design guide, but Ms. Smith's response is saying whoop whoop to me, sort of given, is that the role of the design guide to basically fill out the policies?
I think we've had much discussion about the role of design guides
Yes, I know.
in hearings, and it's no different in this one.
As to whether they are guiding or directing.
They should always be guiding, and I think that's the purpose of the process we're going through now, is to ensure that they fulfil that role and
They
they
are
don't
guiding.
direct.
Well, we'll get to that, and I think there is a good argument that 98% of the Heritage Design Guide is guiding because it uses the word consider ad nauseum. But there are a couple of insureds. But putting that to one side, I think I'd just leave. This is another one I'd just suggest to you. This needs more direction. as to what are you trying to achieve here?
Mhm.
Because it doesn't give that to me at all. And the fact that you say, well, we go to the rules, well, this is the policy direction. The rules are supposed to reflect the policy direction of the policy.
Understood.
Okay, so you have some questions?
Just a couple of questions. So the table on page 58, are those white boxes new?
The white boxes represent,
Because when it's got like the operative district plan, so potentially NRD.
Yeah.
Wouldn't the operative plan say it is or it isn't NRD? Or what does
the
the white boxes just confused me, and then it went to
Well,
permitted.
maybe it just means the drafting's impenetrable.
Yeah.
So the colours represent activity statuses at a basic level. So green's the permitted ones, yellow is controlled, orange RD, and the white ones are, yes, as the chair points out, nobody really knows how to interpret the rules, or there's a level of discretion as to what that activity would be in the ODP. Yeah.
Right. Yeah, I'm with you.
Yeah.
Now so at the end of end of paragraph 242, the last sentence says, but would recommend around the temporary works, would recommend the Wellington Heritage professionals to suggest wording should the panel. So is that they haven't suggested wording yet, and we should ask them for such? Should we?
The question is whether it's in their evidence.
Yeah.
Because this was written before their evidence, of course.
Yeah.
Yeah, so there's nothing more in the evidence from memory, and it was.
We've got scope to do that.
Yeah, definitely.
Yeah. Okay. Yep.
It's just if you're of the view that there's the potential that it might be abused in what is temporary, or what's the what are temporary works. The intent is that if people need to shore up buildings because there's a risk has been identified, then there shouldn't be any barriers in the way of doing that. And there will always be arguments around how long is temporary or not. But it's one of those things where on balance I didn't. There's nothing for me to go on there, and I wasn't going to suggest 28 days or whatever. It depends.
Yeah.
I have one on that table too, Mr. McCutcheon. The table's really useful. I wonder whether you could extend it to include the other rules down the side, like full demolition, partial demolition.
Sure.
Yeah, and because that's really focusing on really the some of the seismic stuff, isn't it? And
Yeah.
But just as a resource, that would be useful. And if you're able to on the notified and recommended, if you can provide the rule number.
Sure.
That would be useful.
Okay. Onward. Suggested wording on page 62 for P5. The language thing in number 2 is the providing surplus, the word providing. They enable works to build heritage that support a sustainable long-term use.
You could read it as surplus, yes. The reason that it's there is this policy is considered when people are applying for a resource consent to do works to alter a building. And so it's coming from the approach that works need to be done in order to give to support the place provide a long-term use, but it could probably be deleted with no real change.
And I know that the order isn't material, but should that point, given the strategic objective that you've focused on and emphasised, should that be the first element of the policy. That's the number one thing, sustainable long-term use.
It could well be reordered up to number one. I wouldn't have any issue with that. At the same time, I can see the views of some saying that number three should also be the first one. So,
to me, that's a how rather than what you're trying to do.
Mm.
Removal of next one I had is 280. Where a chimney is part of the primary elevation of the building. Can you explain to me what a primary elevation is in that context? So me asking Commissioner Lutz at afternoon tea.
so primary elevation, let me just put up the definition, absolute clarity, is a definition and a location for assessment that's also used in the character precinct. So you would have traversed that in stream 2. And what that means is the elevations, there could be more than one, of a building that contributes to the architectural character or streetscape. Definition continues to note that it's usually the most prominent and detailed elevation. And in corner sites, both sides, both elevations are considered primary elevations.
So it's a defined term.
It is.
The paragraph 282, you've thrown it back to us to say if we were of a mind to reopen the issue of demolition of primary features on pre-1930s buildings. Is that coded language to say it's not in scope? But obviously we could consider that based on the enlarged discretion we have? Or is it more that you haven't recommended that?
What I'm saying is it's definitely worth looking at because there's a regulatory misalignment now where the character provisions are more restrictive when it comes to this activity than the heritage ones, and I don't think that's quite correct. I'm sure there is scope within the many submissions around the demolition of character buildings and the rule framework that manages that. You could explore this issue. I'd be surprised if there wasn't. But to my mind, I don't think it wasn't trivial. I don't think it was really talked about at all.
You'd be surprised if there wasn't scope, did you say?
Yeah.
Okay. And Mr. Wellington might be aware of this. In the hut situation, the legal advice we've received is that there is a scope issue in relation to demolition. And that the controls have to relate any restrictions on density or any restrictions on development need to relate to density and height only.
It's a very quizzical look, Mr. Whittington.
I'm trying to recall if the scope issue is one that
you might not have come across it, but which took me by surprise when I heard that, particularly coming from the Wellington and Porirua situation. So, I mean, to put that in context, the council officers have unapologetically said they've taken a minimalistic approach to implementing policies 3 and 4. They've even said that the drivers are not capacity. It's simply implementing Schedule 3A and Policy 3 and 4, regardless of what the capacity issue is. So, but they've made it clear that they don't believe that introducing demolition rules, say into heritage precincts, is part and parcel of ADE.
The main response.
No, there's no question there, but you raised the issue about thinking there was scope.
All I would probably add is that we have the demolition rule in the operative district plan, and it's nothing new in our context.
Yes.
Yeah.
So did Hut.
Oh, interesting.
Yes.
Maybe that's another point, the difference of a plan change, that the council is trying to confine the ambit, whereas everything's in the basket. It's just which basket it's in.
Yeah. For example, and just for context, the rule that has been introduced with the heritage precincts is a height and number of units rule. So the height must not exceed the height that existed on the site at the time of notification of the plan change, and the number of units the same. So,
well, I think that to be fair to Mr. Wellington, we should invite him to think about that and revert in due course rather than give us a.
I'm not asking for advice on how.
I've already accused Commissioner McMahon of that once.
Look, that would be helpful, but for a slightly different reason.
Yes.
The reason being that one of the submissions proposing a demolition control, which the council officers in the Hut area had then said was out of scope, was by Kaiga order, and I was pursuing that submission.
Yes.
But I've just checked, and Kaiga order is no longer pursuing that submission. So in the end, I didn't address you on that, and I didn't address that issue in the hearing. So I will have to now think about what that issue means for here. But it's clear that the position that the Wellington City Council has taken to scope and is different to the extremely narrow position that the Hut City Council has taken to scope.
And the suggestion by the chair is that a reflection of the fact that they're dealing with a plan change as opposed to a full review, or is it some other reason?
I think it's some other reason, but it could also be associated with that.
Okay.
So I will have to think about it and chat to Mr. McCutcheon about it probably.
Okay, well, as I say, that it's quite a well, I'm going to say a subtle point. It may not be subtle, but certainly complicated. So we'll certainly, by all means, take time to think about it. We've said that paragraph 292 where test does not detract from the identified heritage values. Where is that test stated?
Yep. So in the context of additions and alterations, that policy 7, the policy directs decision makers to provide for additions and alterations to and partial demolition of heritage buildings and structures where it can be demonstrated that the work does not detract from the identified heritage values.
In the spectrum of policy directions, is that akin to an avoid policy?
I don't believe so, given that the express direction is to provide for works, and when coupled, when looking at the rule, which is rule R7, the matters of discretion include policy 7 as well as policy 2, conservation plans, policy 5, which is an enabling approach, and that is providing direction to enable works that we just talked to before about sustainable long-term use and increasing resilience, etc. So it's an express direction to look for reasons to grant consent for works that achieve those outcomes I just mentioned, and that do not detract from heritage values. Other plans use phrases like protect and maintain.
Just looking at that wording. The work does not detract from the identified heritage values having regard to the extent of the work. It supports long-term use. Given that the precondition is framed in the negative, does not detract. How can the fact that something supports a long-term use actually demonstrate absence of detraction? This goes back to your previous point, which says you can have things that promote a long-term use that do detract.
And it's a question of often a question of scale, but also of all of those matters in clause 1 through to 6. So if the work is unreasonably visible, I'm looking at clause 2 here, from street frontages, that it totally removes the ability for the values of that building to be appreciated, it is likely to detract. If the work uses or results in a substantial loss of fabric and craftsmanship, or isn't compatible with the scale and form of proportion such that it detracts from the identified values, it would not be achieving the intent of this policy. So it's trying to set out a framework that both looks for reasons to grant consent, where it places the scale of work, the scale of your rooftop addition is might be, say, 1 or 2 stories and doesn't overwhelm the composition of the heritage building and its architectural features and form that's made of compatible materials. But if that addition with, say, 4 stories, 5 stories, and was bigger than the size of the original heritage building and dwarfed it, used materials that were in complete contrast and not in a good way, then that addition might detract from the heritage values of that place. It's I find with these provisions, it's a horses for courses approach, right? It depends what someone applies to do, and it's dependent on the values of that building and how important form is, or scale, or materials, or style. It might be that the place has more social values than it does architectural values. But there are some common principles of things that need to be assessed, and whether they will detract from heritage values, and the intent is to list them here within clauses 1 through 6.
It's sort of the juxtaposition of the does not detract is like a double negative. And got all these positive things, things that are framed as positives, or that you're testing the extent to which they're positive. And so I'm left thinking, well, all right, you've got a great case that this promotes a sustainable long-term use. What relevance is that to whether the work does or does not detract from the identified heritage values?
What it's trying to do is to, in the resource consent assessment, give scope in this restricted discretionary activity for the consent planner to consider, does this activity, or do these old additions and alterations support this place having a long-term use? So might be in the examples we talked about earlier, to change a use to increase its functionality. do these additions and alterations help achieve the strategic direction and our aspirations for heritage buildings that they have a use? At the same time, it's not additions and alterations at any cost. They need to be done in a way which doesn't detract from their values.
Like effectively, I'm thinking you're in a consent assessment thing. Does it have a sustainable long-term use? Tick. Then thinking, well, so what? This doesn't tell me whether it detracts or doesn't detract from the identified heritage values.
It's not so much supposed to be a tick box. Does it have a sustainable long-term use? It's set up by the first clause there, the extent to which the work helps.
But even if you say it's 100%, like the extent is it's completely in favour of a sustainable long-term use, I still think, so what? It doesn't tell me, it doesn't go, there is no causal connection between the two. Now, that might be the structuring of the policy that it's in the wash your mouth out country, but it's like you're promoting what we used to call, before it got a bad name, an overall broad assessment that you're looking at an unders and overs position. But this is sort of saying, well, you're sidling up to having regard to this, but I'm thinking you've got one element here. Yes, it's a big tick, but how does that go to the primary question, which is, does it or does it not detract from the identified heritage value? Like, maybe there's no answer, and I'm just going down a rabbit hole here. It just doesn't quite seem to work to me.
It is the exact same structure that the Porirua plan follows in terms of having regard to a list of matters. So I don't consider that it's a...
That might be wrong too. You don't want to be too.
I don't think there is an easy answer. And there never is an easy answer when it comes to resource consents for subjective value-laden works. I don't think you can rewrite the policy in a way that says you must minimise visibility from street frontages. You must promote, enhance, recover or reveal street values. You must design the work in a way that allows it to be reversed. I think these are all considerations, however we try to get around it, that need to be considered in the round and on balance.
The paragraph 295, you're saying you don't agree with Foster and Melville that say many buildings are included for their architectural merit, not being able to consider retention of the main determinants of style would remove the ability to manage those values. The question in my mind was whether criterion should be tagged to those buildings have been included for their architectural merit. Because if they haven't been, if that's not the relevant part of the relevant historic heritage values, it's in the so what category.
I think to some extent it might take care of itself, given that the policy is considering identified heritage values, and so there needs to be an evidential basis that it's assessed against. And in the case of the reports that we have, as council has, assessing places against policy 21, which includes things like architectural merit, it would take care of itself in that way. Smith,
Sorry, I'm thinking about how you'd actually use it in the circumstances, and I actually just need to think about it for a while before I can.
Because and similarly, like concept in my mind, you're saying is to the, you'd add on the end in brackets, to the extent that's relevant to the heritage values. And it'll be the same for D too.
Yeah, and maybe for E, it's like, I mean, you could add on something like where setting is important.
E is identified values, minimise the loss of fabric and craftsmanship. Again, if all the fabric and the craftsmanship is internal, and it hasn't been listed for its internal values, like, so does it need to be tied more clearly to the identified values? These criteria, do they need to be tied more clearly to the identified values?
Well, I think
or where do you think the chapeau is enough in that regard?
I think it's enough, because the start of the policy talks about identified values, and I think for a lot of these clauses, I mean, you could add on. I mean, take E, respects the identified setting of the heritage building or structure with its setting. You could add on something like where this has been identified in the heritage report as being an important part of its values. I don't really think that. I think that just adds more to the policy with little
More
benefit.
words and less meaning.
Yeah. That's sort of the conclusion I've come to. And where these things aren't that relevant, like if the work's not to increase structural stability, accessibility, or means of fire, then it gets probably a one-liner in the resource consent that this is not relevant for this replication, because it might be for changing a window. For some of them, there won't be much assessment required depending on the particulars of the resource consent application. There hasn't been any change in circumstances because there hasn't been a fire, and number 4 gets a tick.
The suggested amendment to 1A on paragraph 302. Is functionality part of sustainable long-term use? That sort of suggested that they're different.
I think where I got to is that earlier I had agreed that it's pretty much within the concept of sustainable long-term use, and the reason that you would apply for a resource consent to do additions and alterations to a building is probably driven by the want to use a building differently than how it enables you to use it at the moment. So I think this submission in particular came from the Parliamentary Service, and what they were asking for was an overt reference, and I considered, is there anything to be gained from having it there or not having it? But I think on balance it's okay to include it there, just to help increase the prominence that people will do works to buildings or want to do works to buildings to increase functionality. Of course, I totally accept it's already within the concept of sustainable long-term use, but a bit of an olive branch, I thought that would be helpful.
Suggestion, should it read its ongoing functionality, or should it be again or leave?
I think it could be either. I mean, the subject of the sentence is heritage buildings or structures. I think it could be appropriate, but equally removing it wouldn't be disastrous either.
And if we're throwing olive branches, maybe in the primary issue of sustainable long-term use, you could reverse them. Support the ongoing functionality of heritage buildings in order that they have a sustainable long-term use, something like that, whatever. You can throw them around. Make that point, that make the connection rather than suggesting that they're in some way different. Your suggested revised policies 319, repositioning and relocation. They both use the same terminology. Proposed siting will be appropriate in what respects?
So what it's intended to refer to is that if, for example, if a building, the setting of a building was important because it was on the waterfront, you probably shouldn't relocate it into a rural area. And in the first instance, you should probably try and keep that connection to the values of the setting, which are important to the place. At the same time, if the building did have a reasonably prominent location within the urban environment, you shouldn't, if you were to relocate it or reposition it, not hide it behind another building if it were built to be a prominent feature within the streetscape.
Should therefore say something having regard, be appropriate having regard to those values. Because that's the connection you're drawing.
Mm. I think it could say that, yes.
So think about that. Looking at the next um, 340. I was intrigued by the words unique form and scale. Are they genuinely unique?
They are in the context of the built environment now, and the reason that they have a different form and scale to areas around them is that they have been protected from demolition, and they have a lower scale and form, a consistent lower scale and form compared to areas around, so that there is a degree of contrast with the remainder of the city centre and centres environment around them. And in the case of the waterfront zone, our waterfront is quite unique in that it is very low rise. It's not built right up to the edge. There's a sense of openness within that space.
The got a number of heritage areas that aren't in any of those zones, of course.
Mm.
And what I was actually thinking of was whether they're rather than unique, it should be their particular values, because some of the heritage areas are similar to the other heritage areas.
I think that would be acceptable. Yeah. And the reason that I think I've explained it in here that there is no reference to the other zones is because they don't have height limits assigned to them in their recommended HHS1 standard. And I suggest that if you are of the view when you're considering the built form of our residential areas and centres areas, that you might wish to consider whether you should bring in specific height limits for residential zoned heritage areas. The reason that there aren't in there now is that in the medium density zone, for example, there's a maximum 11 metre height limit, and that is considered appropriate and not for managing heritage values, such that there's no need to introduce another height standard within the heritage chapter.
My next one's 380. This is the same terminology. Will not detract from the identified values of the heritage area. Is that too high a bar? Only allow repositioning. Where it won't detract from the identified values of the heritage area. Detract in any way, shape or form. Like I asked you before, if that terminology is akin to an avoid policy, and you said no because you're testing the extent in the earlier policy, but this isn't testing extent. This is just thou shalt not detract from the values of the heritage area.
I can see what you're saying, especially when you can compare it with in 381 below clause 1, there is a threshold which is specified in there being no significant adverse effects.
Well, that too. Like that, something for you to ponder. Oh, so paragraph 412. This might be the Argosy legal submission. I just wrote myself a note that you might have inadvertently lost the ability for internal alterations where the interior is not scheduled. So this is rule 3. now been renumbered, all 7.
Yes, I did. I wrote down some options the other day for how we can address this, because certainly it's not the intention. A couple of options I've come up with is that can add the word external to the rule title, so it becomes external additions and alterations and partial demolition.
That'd be a problem for the one site where you have scheduled the internal.
So that's not ideal. Other option is we keep it as is, and we recognise that the protection required column of Schedule 1 identifies that for 99% of buildings, it's only the exterior building envelope that's protected. So I don't really see this to be a great issue. The places that do have their internals listed is noted in the noted in Schedule 1.
Well, this comes back to the suggestion that if you define a heritage building on the basis of the bits that you've listed, because unlike the facades where there's only 10, this is 99.9% of them are just the external elements.
Correct. Yeah, I don't really see that it's a big deal.
So, but that would be an added reason for the definition
Correct.
that you suggested.
Correct.
To clean up this.
Yes.
Paragraph 454. You got one with it? Talking about emergency activities. Which is all very well but 330 only applies to network utility operators, and I think it's and for the councils, doesn't it? That wouldn't be much help for a private landowner.
I'll have to check the scope. 330, but the intention is that the rule for total demolition that I've recommended is to apply for, shall we say, in inverted commas, run-of-the-mill demolitions. So when there isn't an emergency situation, when today, tomorrow, someone is coming to, hopefully there's not an emergency situation tomorrow, get in touch with, comes to apply for a resource consent for total demolition, what is the framework? So it's supposed to be for BAU rather than any extraneous situation which might mean it wouldn't be appropriate to require a resource consent for total demolition, or for that consent to be notified as a reason, a turn off for people to apply for a total demolition consent. So my point was that if there is a reason in which a building needs to be demolished under urgency, and people are worried about the resource consent requirement for it to be automatically publicly notified, then that wouldn't be an issue in an emergency situation, because the building would be demolished without the need for a resource consent. Therefore, the requirement and for the BAU total demolition application isn't an issue.
My point would be, yes, that's all very well if the council's the one that drives the bulldozer in. The council certainly has a defence, but and a network utility operator would have a defence, but no one else does.
So
Wording, any person exercising emergency powers during a state of emergency
Was it?
declared
Was that the
or,
context?
or transition
thank you.
period. Oh, well, that's emergency works under the civil defence.
Yeah.
But for that's 330B.
Those were the kinds of scenarios that I was referring to.
I think the issue is,
Talks about person, authority, network operator, or lifeline utility.
your life utility is the one I have in mind.
Reflecting on an example I mentioned earlier about 128 Abel Smith Street, Miss Smith will hopefully be able to talk to the context in other situations where she's been present, where buildings have had to be demolished in reasonably urgent circumstances, because there is a level of, shall I say, pragmatism involved when it is clear that a resource consent is going to be granted and there's actually no regulatory benefit in doing so. Miss.
Yeah, so one of the buildings that came down was a utility on Lifeline Utility. It was about getting the ferries into the harbour that was supposed to be delivering water if we had a massive aftershock in 2016. So that one came down under the Lifeline Utility provisions. And then the building on Abel Smith Street was all of us standing in the middle of the road with building and BCC, the fire trucks, and just looking at this building and trying to come up with the best, most pragmatic decision that would work for those situations. So yeah, it's a tough one, but the council's, well, Wellington City Council is pretty good at making those pragmatic decisions, I thought. But you guys are the planners, so you have to work out how to make the rules work. I know how it works in practice. I stand in the street with a guy in fire, a fire truck, and a guy in a yellow suit, and a couple of people from BCC. And
You're invulnerable with that high vis gear on.
the fire truck's quite nifty, so you have to jump out of the way. Yeah, no, I know what it's like. I know what it's like having to make those decisions, but the rule stuff, I'm going to have to defer to you guys.
Is this not like the Christchurch Cathedral example? So, because there are a number of ways you can make a place safe. Don't necessarily have to whack it. You know what I mean? You can put a fence around it and make up a decision as to what we're going to do with the building. If so is this the justification to whack it where there are other alternatives that could make the building safe still? Does that make sense?
Yeah, no, I hear you. So in terms of making a decision about whether you're endangering the lives of more people by that building staying upright, those decisions are made quite quickly.
Anyway.
Yeah, because the fire guys are very persuasive in those moments, and they've got the big truck and the flashing lights, and they will tell you exactly what they think is going to happen next. And the building consents have to make a decision whether they think that's right, and it can be quite compelling. In terms of the Christchurch situation, the Building Act would kick in if we had a major disaster in Wellington, and then you get the red zone the red zone sort of thinking is now built into the Building Act, and it does a lot of very specific stuff. So I think we have to be thinking about individual buildings when we're thinking about an emergency situation.
Rocking on. The your response on what used to be Rule 11 is to shift out the permitted activity commission, create a whole new lot more permitted activity rules, and then have a converted to a restricted discretionary activity rule. My question is, should that RDA that results, you now numbered Rule 19, be subject to all those permitted activity rules? Because on the face of it, you've got additions, alterations, partial demolition of buildings and structures within a heritage area, including non-heritage buildings and structures, are an RDA. Stop.
Let me check. I think something funny might have happened. Then, as I understand it, so R11 is new buildings and structures. The only additions and alterations.
Well, no, I think it's the old. I was reading that as relating to the old R11. You renumbered everything because you inserted all these new ones.
Moment. Oh, so okay, the R11, what it was the hook in the notified plan for the internal works. Now that I have added two new rules for a new rule for internal works, including works involving the creation of new floor levels and internal seismic strengthening. The permitted activity parts can come out.
Yeah, my point is that does the resulting rule need to be subject to those permitted activity rules? Because otherwise you've got two conflicting rules. One that says it's permitted, one that says it's restricted discretionary.
I think this is much the same as, well, in this case, I think it's just that if you're doing the new floor internal works, then you're a permitted activity. But if you're not doing that, then you're automatically RD, which makes sense.
But my point is,
yeah,
that your temporary in your internal works are still additions, alterations of buildings.
Oh, I see what you mean. I mean, you could do that. That's not. You could absolutely do that for crystal clarity. You could have excluding rules, works provided for in rule whatever it is. I know that's not the framework. I mean, you would also then have to do the same for external chimney modifications. You would have to list that one as well.
But like, it just seems that normally you avoid that because they're all in one rule and you're cascading downwards within the rule.
Correct.
But the way you've altered the structure of the rules.
Yeah.
So you've actually got different rules covering the same activity.
Yeah, from a big bucket of additions and alterations I've got.
Yes.
Yeah, within it. Yes, for clarity, I think
like the way I've normally seen it done, there is some tag that's not specific. The tag that says that's not specifically provided for in another rule.
Yeah, I see. I understand the question now. Thank you. Yes, that could definitely be done for clarity.
Oh, 492. I noted that the amendment you said you agree with doesn't appear in your Appendix A. I don't think. Could be wrong, but can I just suggest you check that?
That for you.
question for clarification. Rule 20, alterations to enable building access at ground level of 32, the terrace, the Braemar building. So there's a consent order made in 2008 that it authorised this, and it hasn't happened yet. So what's the lapse date on that consent?
I do not know.
And is the consent still live? Which is the other way to ask the same question.
Mm.
Something for you to check. Four. Right. You turn to your Appendix A under what was S4. The first one, the B&Z Centre, which I always thought was the big black tower over there until it was renamed firstly State and then Aon. I've never associated the B&Z Centre with the quote old bank. That's what it's called now. So that's a question in terms of heritage.
Yeah, that's the name of the heritage area in the operative plan, and it's just been rolled over, isn't it? What should it be?
It should be the BNZ, as in the four BNZ buildings / head offices heritage area, because it's the head offices of financial institutions that came to the capital city, plus the BNZ.
If it was the MLC,
Yes.
is where Quest Apartments are now.
Yep.
The old bank, obviously.
Yep.
And what's the one on the other corner?
Oh, so it's all of those. It's like a financial district.
Yes, it was a financial district, but,
yeah.
but it's not the BNZ Centre.
No, correct. Absolutely correct.
I'm very familiar with that part of town. Just check.
Indeed.
Yes.
The oh, yes. Commissioner's poking me and thinking he needs a cup of coffee.
Not at all, not at all.
You know, passing notes at the
We'll
front.
have a break. I think probably Mr. McCutcheon needs a rest for a moment. We don't.
Not so much coffee, something else.
I think there's too much information gathering.
Yeah.
Resume the hearing. I'm up to the discussion of the Heritage Design Guide on page 103. Wondered about the implication of the suggested amendment, Mr. McCutcheon, at 596. Suggested to me that the treaty partners are not New Zealand's peoples, and I wondered if that's what you meant.
That was the point that was raised by Wellington's heritage professionals, who said that.
But it might be including these treaty partners.
I think where it gets complicated is that the Crown is the treaty to the partner to the treaty, not New Zealand, not the people of New Zealand. I know it's not a technicality.
But certainly on the other side, as far as I'm aware, the assembled iwi are people of New Zealand.
I thought that saying both treaty partners meant everybody.
Well,
But
like I understand the point, but I think it just needs to be including rather than and.
yep, I agree with you. Yeah.
It's a simple fix. Replace and with include.
Happy with that.
Your discussion at 605, Mr. McCutcheon, and I'm thinking, do we even need to go there? Is a further submitter opposing a submission that supports the existing text a valid further submission? Since the definition of a valid further submission is something seeking something between the existing text and what the primary submitter seeks, and in this case there is no gap to make a submission on.
Being responsive to submissions.
Some would say over keen. So, as I say, I've always understood that you cannot make a further submission opposing a submission that supports a plan. By definition.
Just on that issue, and you didn't really touch on it this morning. I don't want to get into a lot of detail, but when are the heritage design guides triggered? What presumably as a matter of discretion, presumably. Can you give me a typical example?
Certainly. So the heritage design guides are connected to the policies of the heritage chapter in essentially the same way that they are in the residential zones. So when if I turn you to HHP 7, recommended HHP 7. P7, yeah. Yes. Clause 1 starts the extent to which the work, and then J talks about fulfills the intent of the design guide. Okay. So it's a very similar way in which the connection is constructed with the residential design guide.
So what we don't see is a direct reference in the matters of discretion to the design guide, but a reference to the policies that then reference the design guide.
Yeah.
Yeah, okay, I was looking for matters of discretion.
Yeah, I totally recognise you could do it either which way.
Yeah, no, that's arguably more efficient. Yeah. Thank you. Sorry for that interruption.
622. the response seems, I can understand there's no evidence in original form. But the submitter talks about little evidence remains. Clearly that will be on a sliding scale. It will be everywhere between a lot of evidence and very little. But the submission, so I don't think your response answers at least that part of the submission. What happens if there is some but very little evidence?
Where there is some evidence, so for example, there might be photographs of what the shop front originally looked like, might not be particularly detailed. That should be, if the works are intended to alter the front of the shop and it's within a heritage area, for example, the guideline suggests that you should look to restore or reconstruct. I agree it could do with some tempering. Those parts of the shop front where there is evidence. So if there's a little bit of evidence, you should take practical steps to try and incorporate it within it. And I recognise that's not what the design guideline says at the moment.
That was the other thing I was going to ask you. Should it be evidence? Because as you say, evidence could be a photo of what used to be there and is no longer there. Should be where there is little physical evidence. That it's sort of at the point when all you're relying on photos and saying, well, you should, is it too far gone at that point?
So one of the things that supports the guideline, the statute guideline, is that there is actually a bit of work that council has put together to demonstrate different types of shop fronts that are very typical for Wellington. So there is some background information that explains what the evidence can be and explains the kind of styles of shop fronts and verandas that we typically expect to find in this kind of building. The reason a lot of evidence isn't available is a lot of these buildings, the elevations was drawn as a sketch, or sometimes there wasn't even an elevation of the building as part of the original building consent set. And so we are then, for heritage areas, we're looking at what's typically happening in that heritage area, and there's enough information internationally and the work that we've done at Wellington City Council to indicate what a good shop front looks like that could go back in those places.
But my point is, if a shop front now bears no resemblance to what was originally there, there's a question about, well, on what basis has it been listed, but just put that to one side. Is it appropriate for the guideline to say, well, we should be manufacturing a heritage shop front out of something that's completely not heritage?
I think what the guideline needs is a bit of tempering in the way that the others have, where they talk about consider doing an action, because turning our minds to the policy, the extent to which work recovers, reveals or enhances heritage values, i.e., by putting a shop front back to what it originally was, is one of the matters which a consent planner would have regard to. Doesn't mean that an applicant has to do it, to restore it back to what it was. So I think this addressing the situation might be achieved if the guideline G16 was tempered that maybe into like a more of a consider point or about recognising the benefits of restoring or reconstructing shop fronts, rather than coming across slightly blunt as it is at the moment, that they should be restored or reconstructed.
I'm just wondering if that whole G16 comes from a completely, not completely, but from a slightly different angle. That means in terms of a conservation process, that you should only restore or reconstruct shop fronts where there is evidence of the original form and detailing and materials. You should not use conjecture, and this would be using, oh yeah, they were all roughly the same there, so this is what we are restoring. That's conjecture, that's not conservation. And I think that the basis of that might actually come from that. You know, you can only do it when you have the evidence for it. If you don't have evidence for it, you can't.
Yes, I agree with you completely. But I also think that there's probably a kit of parts in there that you would expect to see. So if you see a photograph, if you have enough evidence that the shop front was there, and you have a drawing, and the drawing roughly shows a panel door, then there's enough of a kit of parts for you to be able to, for a good conservation architect, to be able to put together a panel door that will fit that space. So I think we're both saying the same thing. And I think that the non-statutory design guide gives a bit more guidance on the things that typically happened in that space, so that when you look at the evidence, when you look at the photograph or the very rough sketch that you might have had of the old shop front, you might be able to interpret that evidence in a better way. So hopefully we're saying the same kind of thing, I hope.
Yep. Just in addition to that, Foster and Melville were talking about, and that's what Mr. Chair has actually been alluding to, if there is no heritage fabric remaining. And your assessment to that was that there is there's evidence of original form, but that evidence, of course, does not necessarily need to be physical evidence there. It can be a photo or a plan or whatever it is. Just to clarify that.
My question is whether that should be the position. At the point when there is no original fabric left or very little, this is where the angle of the submitter, is it too far gone to be contemplating, even on a consider basis, restoration?
I don't think so. I mean, I know of, I'm thinking of examples in a residential context. Like I know of a fellow planner whose railway house had different windows put in it in the 70s, for example, and the bays had been removed, and there were now just aluminium windows straight on the front of the house. There's none of the original fabric that what was there remaining anymore, but there could still be a positive heritage benefit if they were of the view to put it back to an original form using new materials, of course, sympathetic ones, putting a new bay window in, painting it the same colour. So I do see some benefit in retaining the guideline, but I think it should be tempered down to consider work, maybe something like recognise the benefits of restoring, reconstructing, if appropriate. It probably might not be appropriate in all circumstances, and I think Ms. Smith touched on some examples where there might not be a great deal of certainty, but where there is a level of certainty, I take her advice that it might be a good thing to do, but it isn't required by the plan.
That's maybe Ms. Smith can actually answer that question or clarify that. With regards to the restoration, where does the council draw the line between restoration and reconstruction? Because I think this is what you're referring to. If there is a certain amount that is restored, that it's not the majority, or I don't know, that's the question. How far does the council see restoration being restoration before it comes reconstruction?
So, funnily enough, the times where I've really got caught in, gone into this in depth, have been in times when people have proposed restoration, and we've been looking at why that's the right option for a building. So in terms of shop fronts, where the original shop front's has been lost, and we don't know what the original shop fronts are. The example comes to mind of the JC building, which is just on the other side of Willis Street. And between the conservation architect and us, we couldn't work out what the shop fronts were from any way of working out how they were. And what we came down to was that the thing that remained of the original shop front was that there was glass in a particular line. And that was what we required, that they didn't make a smoking bay, or they didn't take the glass off. They kept that line of glass. So the times when I've actually really kind of had to go back to the design guide is where people are trying to maybe offer something up that's not quite right, or to look at the situations where a building owner wants to restore something and try to consider what they're proposing. So I don't think there's been any. I mean, there've been some circumstances where in a heritage area we have suggested that we're looking for something that is in keeping with the architectural style of the heritage area. And in those cases, we were asking for things like an upstand to the window and but in those circumstances, I think we're actually looking at the effect on the heritage area and on the other shop fronts that are part of that collection. So, I find it quite a difficult one, because coming from a background in the UK where there was a kind of a pattern of how things were done, I found there was more support for putting traditional elements back in buildings where you'd expect them. And coming to New Zealand, I find that there's a different point of view on that one. But I think that we could get the right wording in this design guide that reflects the kind of New Zealand expectations of conservation in that space.
Exoskeletons, G40. It's the submission.
Yeah.
The discussions at 636. Understand why, from a heritage point of view, we want to discourage exoskeletons. But should this guideline make a nod to the fact that unless there's no reasonable alternative, because if it's a choice between exoskeleton and knocking it over,
the reason
clear, well, unless the exoskeleton is pretty over the top, that would be the lesser of two evils.
agree that keeping heritage buildings is a better outcome than having them demolished. But the reason I haven't adopted the submitter's wording is that reasonable alternatives for exoskeletons is not a framework that is set up in the policies of the plan. It's around not detracting from heritage values in additions and alterations. And so I didn't think it was appropriate within the design guide to introduce a slightly new take on where exoskeletons sat relevant to internal strengthening, but and I thought that the G40 as it was accurate in that they are likely to lead to adverse heritage effects in all but a few cases, and they should be discouraged. There are a few other things about exoskeletons which can make them particularly problematic, and that often they encroach on footpath space as well. So there's a public accessibility impact on them as well. Well,
the council can control that.
It totally does.
Encroachment.
Yeah, yeah. And it is another factor that flows into that, weighing up whether that is a good outcome or not for the resource consent planner in that assessment process. So yes, my 2 points being, I didn't think it was appropriate to introduce another threshold in the design guides, which wasn't already set out in the policy.
I suppose the question that might then be, is that a regulatory gap in the policies?
I don't think so, because in the context of a resource consent, and there's a conversation which occurs between resource consent applicants and council's heritage and planning advisors around, what options have you looked at? Are we convinced that this is the only one that's viable? Why is internal earthquake strengthening not possible? And in the event that they are convinced that it can't be done on the interior, which is usually pretty unlikely, as I understand, it might cost more, of course. Typically, the heritage effects of having exoskeletons outside don't outweigh the benefits.
I suppose the question is, what happens when the developer is proffering an exoskeleton? You don't get there. Because the answer is going to be, well, that's going to detract from heritage values, so no, you can't do it. And do you want to go down that track?
Well, I guess that's why there is an enabling framework, albeit through a controlled activity status, that we're trying to recognise internal strengthening is a more sympathetic way forward, and we will sort of create a baseline of guaranteeing that as a seismic strengthening option. And in the first instance, that's where you should be looking.
So yeah, I was thinking. Yeah, I think the thing about G40 is it's trying to explain the circumstances where exoskeletons are problematic. And in terms of buildings, the thing about the structure is it takes up net lettable inside the building. And so if you've got a whole lot of apartments that are quite small size, you might find a new bit of structure coming down through the middle of your kitchen in every apartment, and it's really destructive for all the apartment owners, and it means they all have to move out. And so the exoskeleton becomes quite a attractive idea to the apartment owners, particularly, or the unit owners. But then there's all of these other issues that Adam was talking about. For example, the encroachment isn't just on the footpath, but it's in the space under the footpath. And that's the zone where a lot of the services go. It's taking public road for private use. So you're using the public land to put your structure on in some circumstances. It's a great place for pigeons to hang out. And the exoskeleton in the building moves differentially when there's an earthquake. So you can end up with every time you've got a connection back into the building, you can get a slightly bigger hole after an earthquake. So they're not, I think it's worth, we have to have better conversations with people about exoskeletons than, it's not black and white, I think. It's complex and difficult, and we need to have better conversations.
I suppose going back to G40, it says discourage, which, as you say, is not an absolute instruction, but it does raise the question as to when would it be okay, and where is the policy guidance around that?
Yeah, so in my response to this, I think it's 1162. I tried to give you an example of a good example of an exoskeleton, so that you could see situations where it's perfectly fine. And I've got a photo of a hotel on Cuba Street where it was the right answer for the building.
My question, Mr. Cutchin, as a planner, is you're saying have regard to the intent of the, it says discourage, that means it's not an absolute. So where's the policy guidance as to when the exception of the situation is appropriate?
The policy guidance is in HHP 7 when a planner and heritage advisors are weighing out whether the works would detract from heritage values, and they're considering the benefits for increased resilience through seismic strengthening. So it is one of those overall judgment that we don't like approaches, and in determining whether the effects on heritage, there are acceptable effects on heritage values or not. If the building was listed for its prominent architectural style and its intricate craftsmanship on the exterior of the building, then it would be unlikely that an exoskeleton blocking those features would not detract from heritage values, but that would require an on-balance assessment depending on the building.
Okay, that's all I had on the plan provisions. Questions, anything to go? Ms. Smith, State Chair.
I just got one more. Just on 629, the first bullet point where you've struck out works, it just didn't read right. Undertaking conservation with consultation. I don't know, it might be just I was reading it late at night. It just didn't grammatically look, but something to look at. It might have just been me.
Maybe it could do with the word planning or practices or something.
Yeah. But it's not a biggie. Just have a look at that.
Mr. McMahon.
Yes. Thanks, Trevor. So 4 matters for me. Just going back to that table on page 58, Mr. McCutcheon. Strikes me it would be useful to have that earlier rather than later. Just so we can refer to it during the course of the hearing. You might just want to provide a slimmed down version of it in that sense, but just so we can use it as a reference document. Second matter, and this might be just for something you think about overnight, or I've still got this issue of character areas and heritage areas on mind. I'm putting aside the Hut City, but I guess I'm looking at it in the context of places like Mount Vic, where there are both. I'm trying to understand the statutory and evidential basis for identifying character area in Mount Vic and heritage area in Mount Vic, and why and how the council have landed on the spatial extent of those two constructs. I'm sure it's in the 32A, 32, section 32. And I'll just finish it, and then you can, if you want to give an interim response, that's fine. I guess I want to know that from the perspective of how they operate as qualifying matters. Is there any component of existing qualifying matters, 77K in that? E.g., pre-1930s rule, is that? Or was that a character rule? Or we understand how the character areas have been justified in terms of 77I little j. And the discussion we had about the thematic process might assist with how heritage areas were justified in terms of 77IA. But I'm not sure that I'm 100% on the latter. So yeah.
Should I give my best at a fulsome response now?
Yes, let me just note one other thing that might assist. Are there any sites, or how many sites are there, that are affected by the IPA heritage areas or heritage listings that are not a centre or a relevant residential zone? In this case, the inner or the outer residential zones, which then became a mixture of high density and medium density, presumably. So that's
IPA or IPI?
just how IPA. I mean IPI.
I think
Maybe I'm thinking
he's thinking of the beer
Yeah.
afterwards.
Something on the brain.
Yeah. that understand might assist with some of the other stuff. So that's a clumsy way of me sort of indicating I'm still trying to get my head around why some areas are character and why some areas are heritage and localities like Mount Vic.
Sure. So what's the business of all this character and heritage, and how do they relate to one another? So starting with where they come from in the Act. So we've already heard that character precincts are primarily a construct of Section 7 and amenity values. Accordingly, we don't, well, they're assessed for their consistent and coherent character values. That's that definition and that assessment that was undertaken by way of the Boffin-Miskell pre-1930 character area review. Supporting that, property economics in the qualifying matters work, which is available online, has assessed what the impact of, by way of development capacity, is of having these areas in the plan, both as notified and as recommended in Stream 2. In terms of these existing qualifying matters, well, arguably the inner residential zone that we have in the operative district plan with a character pre-1930s demolition rule, which essentially is rolled over within the structure of the PDP and the character precincts. You could call that a qualifying matter. It all seems a bit of a nonsense to me that we have all these controls in the operative plan at the moment. We don't call them qualifying matters, but they restrict building height and density. That's what they are. In terms of heritage, coming from Section 6 of the RMA, we have no national direction on heritage. What we do have is the regional policy statement, policy 21, that tells us this is what heritage is and how you assess it needs to meet these tests. Some, but not all, or the entire extent of what has been included and subsequently recommended in the Section 42A report as character areas meets that test of significance under policy 21 of the regional policy statement. Yes. So there is a degree of overlap between some of the character areas and some of the heritage areas, and that is to be expected given that a lot of them are comprised, or the character areas are comprised of concentrations of largely, or some of them are modest or exemplary representations of architectural styles, which is one of the criteria that we are required to assess under the regional policy statement. This is not unusual when it comes to early development of of a city and the areas in which heritage values and character, this construct of character values are found. There will undoubtedly be an overlap between the two, but they are not the same.
I understand that. I guess my question is, how was it landed in the particular circumstances?
Yep.
For example, I understand the concept of a concentrated, consistent, coherent area qualifying as a heritage area.
Yeah.
And obviously, well, supposedly, Moira Street is an example of that.
Mm-hmm.
Presumably, there are other similar sized or even smaller, coherent, concentrated areas in other parts of Mount Victoria, maybe Thorndon, maybe even Newtown, that could equally qualify as heritage areas, but haven't been shown as such.
Yeah. So further to my response, Ms. Smith spoke to the information sources that we have, the council has had, and that included that Mount Victoria heritage report, which went a great way to identify which smaller areas from the entire suburb of Mount Victoria would meet the regional policy statement criteria. So those are the ones that have been assessed. Accordingly, a report pops out at the end that says they meet the criteria for listing. So those areas have both heritage and character. There hasn't been a conscious decision to, if something meets heritage, can you remove character from it? I think that could well be an option, considering there is a high level of regulation over those areas anyway, such that those character areas, the character values that are being protected are probably going to be managed pretty well by the heritage provisions themselves. But I note that it's not a one-for-one. There are some areas which sit outside, and that's because there's been a different methodology between the heritage assessment and identification versus the character assessment and identification. In terms of why there are lots in Mount Vic and not in other areas, well, that comes down to the information that council has available to it to make that assessment. So undoubtedly, there may well be areas in Newtown or Berhampore, which are within those character areas that we've spoken about, that could meet the criteria for scheduling as heritage areas. We just don't know, and we don't have the resources to track it down and find it out.
Is that the answer, though? Is that the answer?
Yes.
That really the time
Yes.
precluded that occurring?
Time and resources, and there's an element of pragmatism here that if we accept that character is a thing and it can be justified and it achieves by and large what people want, which is the maintenance of character values, to some extent you can make a decision that, well, there's no need to go any further and do a heritage assessment on top of that.
Well, Mr. Lewandowski obviously accepted that because he took us through the qualifying matter, the site by site.
Yep.
The roadmap for capacity assessments and cost and benefits.
Yep.
And was obviously highly reliant in his 42A on the BOFA position, but also took some evidence from submitters and modifying his 42A position.
Yep.
In the supplementary, I think it was, or it might have been in the 42 actually.
In the 42, yes.
Yeah.
Yep.
To give percentage decreases or increases in the amount that was of character areas from the ODP.
Yeah,
So
correct.
Just, obviously there was quite a bit of effort going into establishing these character areas in the proposed plan, using the BOFA MISCL.
Yep.
You had the time to do that. You didn't have the time or resources to consider whether they qualified as heritage areas. That just strikes me as a little bit at odds.
I think so. So the BOFA MISCL work did identify areas which they thought might be eligible for heritage protection. So places like Roy Street and Newtown, they're identified in that report, and they all went into the mix in my diagram that shows this earlier in my 42, where I showed that the thematic process. So those
23.
Yep. So those went into the mix, as did essentially the equivalent identification of possible heritage values through the Becker outer residential work.
Yeah.
If we're thinking, I think the other thing to remember is that heritage is much broader than just the inner suburbs, and that the pre-1930s work had a large amount of resource dedicated to looking at the inner suburbs and character values, and there are heritage values, of course, in the outer residential areas, and the point of the thematic review and the work that we've done more broadly for the heritage listings is to try and increase that representation and show underrepresented themes right across the Wellington urban area. Further to your point, though, in justifying the evidentiary base for heritage listings, so those detailed reports exist. Property economics, also in that qualifying matters assessment, assess the development capacity impacts. So that is another part. Your subsequent question about sites that are affected by heritage but not zoned a centre or a relevant residential zone, the heritage is located, and there are heritage listed things in pretty much all of the zones in the plan, including tertiary.
Are they IPI provisions or first schedule provisions?
So the only one, so the schedules notify that those which are considered within the urban environment are part of the IPI, and it was easily distinguishable because they are more easily spatially identified as points on a map.
You're talking about individual listings here.
Yeah.
What about heritage areas? Are there any that aren't in residential zones or centres?
Yes, there's the Te Rewhiti gold mining battery heritage area. There may well be another one.
So they're what, business zone, industrial zone.
That's rural.
Yes.
Out the back.
Oh, and the batches, yes, at the back of Macra, yes. And Mustaines and Red Rocks batches, which I think might be zoned open space because they're in the coastal environment.
Yes.
But yes, so in the round there are overlapping extents of heritage and character area precincts in some parts of the plan. As notified, both sets of provisions would need to be considered. That is the relationship.
Okay, so what I'm taking from there is that whether though a heritage or character was subject to the available studies that were taken at the time that was available, that you're reasonably confident that you've either captured sites either in one or other of the categories, heritage or character.
With respect to the inner suburbs, yes, there's a large amount of land that is identified as character or recommended to be character precinct or heritage protected.
In terms of the effect on density and height, what's the key difference between being in a character area or being in a heritage area?
So there's not a lot in terms of within a residential context difference in the heights available. So in the character precinct, so if we're thinking in Mount Victoria at Elizabeth Street, for example, if that were just a character precinct, the planning approach has been the medium density with 11 metre height limit instead of a high density residential zone of 21 metres be applied. That one also happens to be a heritage area, so there's no net difference there. If we turn our minds to Tarikaka Street, that is in Ngaio, that is a medium density residential zone with 11 metre height limit there. It's a heritage area.
And is that typical? Is that a typical example?
Yes, the residential heritage areas typically, if not always, have a underlying zone height limit of 11 metres.
Thank you for that, and you're welcome to reflect on that and write a reply. I guess the follow-up question for that is you talked about earlier on about ultimately this plan change is giving effect to the NPSUD. Can't remember where you said that, but I wrote it down, and I just wondered, would there have been a different outcome in terms of heritage protection if this was not an IPI process or being done as a first schedule process?
No, there would be no difference. Before the IPI was even born, we had done all the work to identify proposed heritage listings, and we're developing a rule framework that would not be different in any significant way.
Thank you for that. And my final question, Hutchin, is quite a specific one, and it's about the relationship between policy P11 and rule 13. This is the demolition, total demolition. And we've had discussions about the policy earlier, which is an avoidance policy unless 5 matters can be satisfied. This is the new P11. Yep. Okay. And I just wonder, how does that speak to the information requirements in Rule 13. And that's which was Rule 9 previously. Yes.
So a note,
I already noted that there's some similarity between the Clause 1 and both the policy and the information requirements in terms of maintenance and repair. And you're going to come back to us on what the intention there, whether it's in terms of past or previous, previous or future intentions, or both. But I'm more interested in Clause 4 on Rule 13, which is about sort of a cost indication or condition survey report, and what's the policy basis for that?
certainly.
If I can just explain my reasonings there, I understand what information Clause 5 is trying to do. It relates to seismic matters because there's a clear line back to seismic strengthening as put in the policy. But I'm not so much clear about what item 4 in the information requirements is doing in terms of where a building's identified as being gone repair. There's obviously a condition survey to do that, but there's no indication of what the costs are and whether the costs are reasonable to bring the building up to repair. And I wasn't sure that that's what Clause 1 of the Policy 11 was getting at either.
Cool. So broadly, the intent of the information requirements is to reflect matters that are commonly traversed in resource consent applications for total demolition of buildings. So it's to help expedite consideration of a consent and reduce the need for further information requests to go out where there isn't detail provided, enough detail provided that allows a consent planner to consider whether there are no reasonable alternatives to total demolition. Reasonable alternatives inherently requires an assessment of the economic viability of undertaking works to a building and what the current condition of that place is. So the intent of Clause 4 is to obtain an accurate assessment of what actually is wrong with the building so that a consent planner can consider that and whether a proposal to consider total demolition is justified in light of what's wrong with the building. I think in the same way that 5 below talks about costings, you could absolutely include a point about what the cost of repairing such work would be.
That's sort of what I was getting at, Mr. Cutchin.
Yeah.
It seems that someone could mount a case that going down the seismic strengthening position, because it's a matter, it's a policy exemption, if you like, if we want to put it that way. It's an exemption to the avoidance, and there's information that's required under Clause 5 in the rule. But if you compare that to, say, we're building that's in bad disrepair, and let's not assume why it's got to that stage. It could be genuine, there could have been water damage done through perhaps putting in internal gutters that was seen as being appropriate at the time, but led to an undisclosed water problem that slowly ate away at the building without anyone knowing.
Could be stormwater flooding.
Yes, it could be.
To cater for a currently opposite example.
And there might be a report under Clause 4 that says the building's beyond repair, but a condition survey indicates that. But the reasonableness of that and the cost to bring it up to repair isn't being asked for. But more importantly, it doesn't seem to be part of the 5 matters that will give you a consent pathway under the policy.
I think it's it's wrapped up, all of these information requirements are wrapped up in determining whether there is a reasonable alternative or not. It's not asking, I don't think it's appropriate that the policy ask, you know, whether the costs of repairing the building are greater than the cost of demolishing it and building a new one. I think that oversimplifies.
Although, isn't that what clause 5 is doing in relation to seismic?
No, I think what the information requirements are doing is assembling a body of costings and information which can be weighed up by the consent planner in determining whether it is reasonable, whether all reasonable alternatives such as adding additional floors to that building, selling apartments out of it, or creating new floor area which can be rented out to offset the costs of works.
Okay, we'll put it this way. There seems to be a relationship between clause 5 and the information requirements and clause 2 in the policy of sorts. Whereas with your new clause 4, and I'm not necessarily seeing a nexus between that information required as part of the rule and the policy, and I don't hear you saying it's part of clause 1 of policy 11.
I wonder, Commissioner, is the answer that those 5 elements are inclusory? They're not exhaustive?
Or even if they are inclusionary, I'm just, I'm seeing when you're questioning their reasonable alternatives, I'm not seeing a position that sort of corresponds to what Mr. Catchins added it was for.
What, as I said before, what a consent planner is looking for when they receive an application is a body of evidence which demonstrates that the building is in such a bad shape that it can't be repaired or maintained or strengthened, or it adds an ops undertaken to it in such a way that would offset any work, the cost of doing those works to get a sustainable long-term
That's both the
use.
feasibility, the technical ability, and the overall cost. Concept of reasonableness.
Yep. So within the concept of reasonableness, yes.
Yes. We're talking about that now, but I don't see that. Don't see that term.
Not within the information requirements, but it is within the policy. Yeah.
Okay. Well, maybe the answer, if there is an answer, is in your reframed clause 1. Because it seems that it could be serving 2 purposes, that clause.
It is.
Yeah. And
So
that's the fact that 2 different commissioners have different interpretations would indicate that.
So it is serving 2 purposes. I will accept that. What it's trying to do is say, how much money have you saved by not doing any work to this building over the past 50 years? And in ruling out maintenance and repair as a reasonable option, how much would it cost? Yeah.
I think if that was more explicit, that would answer some of my questions.
Yeah.
Thanks for your perseverance on that question. Just check my notes. I think that's everything. Thank you.
I think we're up to Ms. Smith. Change of approach. Commissioner Watts will take the lead here.
Smith, before we go into looking at the individual buildings and areas, there is a couple of remaining questions with regards to the methodology and the plan in general. We talked earlier about adding the historic places, historic heritage New Zealand. I still get it wrong.
Yeah.
HNZ.
Yeah. I've spent too many years calling it HPZ. To add them to the list without much ado, because the research is there, the information is there. You also have actually had previously assessed heritage buildings assessed by the council that were reassessed again. Now, I can hear you say already that, yeah, they needed to be re-looked at because things have changed, possibly. But one of the questions is, in the light of not having enough time and resources and having 600 things sitting there that potentially might be good, the RPS says that only one of all the criteria needs to apply for it to be able to be scheduled. Why hasn't the policy, the methodology, been a little bit more stringent in terms of saying, okay, look at more, but we find only one, and that's enough for us. We don't need to go through the whole 9 yards to find every single piece that might or might not be relevant.
Yep, I can see where you're coming from. One of the things we looked at when we screened out the database, the 600 things, was the things that we had a lot of information on. And a lot of that research was very reliable because it was done by heritage professionals, and wherever we could, wherever we had good reliable evidence, then we certainly reused that rather than starting from the beginning. And wherever we could, so a certain number of items were sent out to consultants. Some items went to consultants that we knew that they knew a lot about particular properties. But where we had a lot of information, the council did quite a lot of the formatting the reports in-house where they possibly could. So I thought that we'd used our scarce resources quite carefully. I didn't feel that we were, I felt that we tried to get as much as we could for the amount of money that we had. You want to jump in there, Adam, or?
Just an observation I will add as well is that building owners expect that a high quality report with a breadth of information is provided to them as to why their place is important, and a couple of lines just ain't going to do it for people. So from a perception and a robustness point of view, the council needs to put its best foot forward and justify why places are significant. That would be what I would add to that.
Yeah, but I really do think that we did look at our files and see where there's reports. We did look at things that we'd almost gotten to the point that they'd go into a plan change. Why didn't they get through? I did specifically have conversations with Heritage New Zealand about reusing information and the histories and any information that I could do. So I do feel we were quite efficient in what we had.
The other point I would note is that, throughout this hearing process to date, we've heard how important having large evidence bases and quantification of why things have the values that they are is the right thing to do. Another observation.
From an unnamed party who will be hearing from in due course.
Yeah. The other question I have is with regards to the process undertaken and several submitters complaining about that the public was not involved enough or not involved at all in some submissions. You have in your paragraph 43, you said you would agree with some of those submissions and that the process could be improved by public engagement and consultation to identify more places. Is that a recommendation to go out and talk to the people, or yeah, how do you see that?
I mean, heritage is, the thing about heritage is that it's important to people. It's not important in isolation from people. So you kind of have to talk to the people that it's important to work out what's important. So I think without consultation, it's not, you know, without that connection to people, it's not really heritage. Does that answer your question?
Yeah, to a degree. The point was made by the Wellington heritage professionals that with regards to you and Mr. McCutcheon's answer on many things that said, yeah, that people had the chance because they could have actually, they were invited, I think it was a strategic, no, it was a spatial plan that was actually developed, and there was a part on the website somewhere that said you can, you know, tell us what you want to have done. But I also understand that while that was there and publicly accessible, it wasn't promoted in any way to the greater public and saying, look, this is there, there is something you can do. And so far, how do you see that the public was or wasn't included? Because as we see, there's a lot of submitters who have a lot of buildings and areas that they would like to see included, and it doesn't come across like they feel they have been included in the process.
I think put in the context of a full district plan review, which this is cut up into two, historic heritage has been promoted and consulted on in the same way, exactly the same way as we did for significant natural areas. And I've identified in my 42A report where letters have been sent to all proposed listings. There was a website, there was a information brochures put out. We talked about this at both the spatial and the draft district plan processes. In the round, heritage has been through that exact same consultation process as natural hazards, SNAs, character precincts, that I think it has been treated equitably given the significance of all those other matters which we've consulted on as well. If this were just a plan change to do with heritage buildings and the schedules, absolutely, you would, with a resource of 10 people, you would go and put flyers on the back of buses and shove them in people's letterboxes. But in the context of a full plan review, that's not an effective use of everybody's time. So I take the point that we weren't having open nights and community centres specifically on heritage, but we were on the spatial plan and the draft district plan and all of those components that flow into that, including heritage listings. And we did receive a list and quite a number of heritage listings on the draft district plan. And you'll see in my section 32 report all of our responses to those many listings as well. Some of them have of course resurfaced in this process because we have not had the resource in the meantime to go and assess them with all the other places the heritage team has been assessing.
Thank you. Several submitters were complaining about the costs and the restrictions on the building owners for their properties, and about support that needs to be or should be available for them with those costs and with other matters of help. Now you've listed quite a range of things that are offered, from providing advice and the consent fee rebates and rates remission and all of these things. Now, we've touched on that earlier. None of these things are guaranteed, are they?
Some of them are guaranteed. So some of the ones to do with seismic strengthening are not. So some are competitive, so by application, but some are absolutely guaranteed. So the rebates are, you have to apply for them, but there's not a competitiveness to it. And for seismic strengthening, the building consent rebate is not competitive. That's based on getting a building over the line. So I can't quite find the section where each thing is. So, but to do with the seismic strengthening, the rates rebates and the building consent rebates, they're not competitive. And again, to do with the resource consent rebate, that's not a competitive process either. But the grant funding is a competitive process. I agree with that.
Can I just follow on with that, just very briefly? So when we say further to that, the question is, can they be stopped tomorrow? Because if they're in here, you know, we get guaranteed in here is different to guaranteed in a decision made by the council to support something. So they are there, but they could equally be stopped tomorrow, right? All of the things that we just talked about.
I think in terms of council process to cease a fund, you know, those sorts of motions do need to go through a council committee process and follow, you know, the LGA process. But if a council were of a view that it saw no value in supporting owners of heritage buildings to strengthen their building and give them rates relief, then a council could decide to do that. Yeah, I've given my view about whether that's desirable or not to include within the district plan earlier today.
Right. With regards to the effects of the listing on residential property values, we have had extensive evidence from submitters. You have actually had a look at several studies you show in your paragraph 68. And you say that these studies have a range of plus or minus 10%, depending on the heritage listing. Which studies are you referring to? Is that just Dr. Bates' Auckland example, or are there other studies out there that have similar outcomes?
So my understanding is that Dr. Bade wrote the underlying paper where he found
Who's that?
Dr. David Bade. He's a
Spell that.
B-A-D-E.
On the page.
Yes. Yes.
Over the page.
And the footnote, top of the footnote.
Oh yeah, page. Yes. Thank you.
So my understanding is that Dr. Bade and others wrote the underlying paper. Dr. Bade also does the annual Auckland Heritage Counts. So my understanding is that he has updated some of the research from the paper into subsequent Auckland Heritage Counts paper, the summaries that they publish each year. And then I just looked as well as I could to find kind of similar studies overseas, and I found advice from Canberra that seemed to be based on a study, and I found a study from Sydney. But I really thought that David Bade's one was probably the one that when I read it, I understood it the best, and that's the one I read in detail. The other ones are much more periphery to the evidence.
Now, in light of that, that this is a study that has been done in Auckland, and we have heard several times now that Auckland is different to Wellington in a lot of ways.
Not dry for start.
Today, certainly. But in terms of studies from overseas, for example, Canberra and Sydney, from what my understanding is, the Australians have a very different approach to heritage from what we have in New Zealand. And the people also have a different attitude to it. And how far do, for example, things from overseas or even things from Auckland reflect what's happening here in Wellington?
I think the ones from overseas are difficult to call completely comparable because in the UK you have VAT relief, so you have, you know, working with heritage buildings, you get a guaranteed 17% tax relief on that, and in other countries there's tax relief, and some other countries there's much more welcoming to heritage things, and it's just a different environment. So I included those overseas studies as background information. I think Auckland is much more comparable with Wellington than the overseas studies. And Auckland is often a good place for us to get data from because they've got the scale. So they have 2,000 plus heritage items, whereas we have less. Sorry, I can't quite remember the numbers.
Right. Ms. Smith conveniently has paragraph 82 of her evidence, which is 680 scheduled buildings, 39 scheduled structures, 43 heritage areas comprising 930 buildings.
So the issue with heritage buildings, this information about costing is about houses. It's not about heritage buildings, because commercial buildings are quite different in the way that they're valued and in the valuation of them. But houses are owned by people and they buy with their heart and with their kind of brain. So these studies are to do with houses. In terms of Wellington, a lot of our houses are quite individual, so it's quite difficult to do this kind of study that David Bay did in Auckland, which was looking at, you know, the number of bedrooms, the condition, the location. He was trying to get an absolute kind of overlap between the listed and the non-listed, and he had a high enough number of buildings to be able to do that. In the smaller cities, it's always harder to do that, but the answer is we don't have the study for Wellington, we have the study for Auckland, and it's the most comparable study that we have.
So would you say, because we have submitters saying that Auckland numbers don't really stack up in Wellington, and because we haven't done the study in Wellington, do we have to agree or disagree with you or them?
I mean, I looked at one of the UK studies, and they did a study for the entire country that one of their heritage bodies was promoting. And you know, having lived in the UK, London is very different from Sheffield, but they did a nationwide study of what this was. And they seem to think that there was some sort of underlying effect in here. I think that flipping it and looking at the real estate stuff that comes through our letterbox and turns up in, you know, social media, I don't see a lot of cheap heritage houses on the market that I could go out and buy tomorrow. I mean, when I look at the real estate. When I look at the real estate things, I don't see, oh, well, I'm going to go out and buy a heritage place because it's 40% cheaper than any other building that I would be looking at as a building owner. So, yeah, I do think we should be able to put as much weight as we can on the Auckland study, but understanding that Auckland is different.
In terms of the compact form of the city of Wellington compared to Auckland, for example, do you think the price makes, or the reduction in price makes any difference being generally closer to the city in Wellington? Those, you know, more of those houses are close to the city. If you look at Auckland, Henderson is not particularly close to the city, but there's a lot of heritage buildings. Does the fact that you have most of the heritage buildings in Wellington relatively close to the city, and as we've heard earlier, even a lot of them in walking distance, does that have a difference? That make a difference? Does that have an influence on the prices? Are people just keen living in the city rather than a heritage building, but because it's a heritage building, that's just what they get.
From my experience as somebody who has bought a house, I was very surprised at how little there is a price differential between the central city and the suburbs. But I see your point that Auckland is quite spread out. It's a unitary authority, and there's lots of different conditions for the buildings. In terms of the David Bates study, that was very carefully done to match exact likes with exact likes in terms of closeness to the, in terms of location and suburb and the rest of it. And one of the other things he found was that heritage houses were generally more expensive than other houses, but that could be put down to them being in these sought after suburbs that they were in. I do think heritage houses often are in sought after suburbs, because that's one of the ways we sometimes in the past have identified heritage buildings as drive-by listings through the posh suburbs. And that's a way we've collected heritage in the past, and it's been something that we've been quite careful to try and avoid this time around. And Adam wants to jump in, I think.
Just an observation from me that there are a number of submitters who are requesting that the extent of character precincts and the restrictions that come with those are extended across quite a great area of the city. So there's clearly something attractive, despite the land use restrictions that come with those provisions, by living in a character or heritage area.
Cynics might say that submitters suggesting extensions over other people's properties, and as I think Dr. Kerr has said quite forcefully, it's easy to volunteer other people.
Yeah, but I think also similarly, I think that there's actually, I think in a lot of countries and in New Zealand, there is a price premium for a special character area, because you kind of know what your neighbour's going to do. And so one of the people overseas who's really studied this to a great degree is a guy called Donovan Ripkemmer, and he runs a business on place economics. And his studies in America have shown things like, if you're in a character area in the US, your house doesn't lose value when the property market declines at the same rate. It keeps a steady rate. These are sought after places, and even in the very poorer districts where they have a character area provisions, the same thing holds true, that the buildings that don't lose value when other properties decline in value, and that people desire these, and that these have a price premium to them.
Can I ask you a follow-up question about that? I can understand, like we talk about heritage generally, and a lot of people say that heritage equals old. But of course, and this is an issue that some submitters raised because of the modernist homes that have been listed, is there a potential that, while you may well be right, that old heritage attracts a premium, modern heritage might not? Because people don't look at it and say, that's a heritage place. It doesn't have that same image in the market.
So there was a really good English study that came up with the point that anything that was built before World War I had a price premium. So before the end of World War I had a price premium. And it didn't matter if it was heritage listed or not, the people in England like old houses rather than new houses. So I think that in those circumstances, yeah, I think you're probably right. But I do think there is and I'm not going to call it a niche market, but I think there's a popularity to mid-century modern. And again, I think there's a popularity for that. I just can't give you the same study, but there's certainly a study in England that says exactly what you just said there. So I think you're correct on that point. I don't know about the mid-century modern ones.
One follow-up also in Paris 75 of your evidence, you suggest that we recommend that a peer review would be useful. What would that give us? To what end? What would they? So if someone peer reviews the valuation, etc., that has been done by Bailey's and whoever it was the other submitter had, and they came back and agreed, how does that assist us where the methodologies are quite different from the BAID to the valuation that they've got individually on properties? What would that do?
I'm just going to see if Nick has been listening to that question.
I have. I'm not sure that it would add too much to the debate, other than providing more weight, more certainty to the outcome in the valuations you've been given. I took you through my criticisms of the methodology from a sort of a legal point of view this morning, but I'm not a valuer.
Yeah, the reason I ask is the methodology used in the BAID report and the methodologies used in the value are completely different. So I question what a peer review of one would actually achieve. But yeah, and I take your point from this morning there. You're right.
Can I step back and ask Ms. Smith a related question? At what point? Well, you started saying your studies you've identified show a variation plus or minus 10%. And your view is that in the scheme of things, that's neither here nor there, particularly given the national importance of heritage values. At what point would a difference in value, cost imposed on a private landowner be relevant or what point would call the appropriateness of a heritage listing into question?
I've kind of pondered over this for a long time because dealing in the UK with things that have been listed for a long time, so, you know, coming up to 75 years or more, I always felt a little bit sorry for the first person at the point where the building was listed, because the subsequent owners buy the property with the understanding that the listing's in place, and so they know exactly what they can and can't do with that property. And I'm talking about commercial properties actually in this instance, because I think the effect is actually slightly greater, well, is greater on commercial properties, unless you've got a developer that understands that market. Then over time, my view is that at the end of the 75 years, everybody who's bought that property subsequently is has bought it understanding what they can and can't do with it. I don't know what the answer is in terms of the number. I don't know what the answer is in terms of the number. Nick seems to.
Hey.
Mr. Whittington, sorry.
I think it's important to get a fix on your position and evidence, because you and Mr. Cutchin have clearly said, well, heritage values are only part of the equation, and there's a subsequent evaluation as to whether that progresses to a listing that takes into account costs and benefits. And so the question then is, at what point, what's the tipping point for you in terms of your respective spheres of expertise? And then we'll ask Mr. Wellington what he thinks the legal position is. But I think I want to get clear on what your evidential position is first.
Having been conservation architect for a long time and dealt with people who dealing with the big bad developer clients in central London who are pretty straight down the line, my answer is that in terms of heritage buildings, they have always found a way of turning a profit, and they've always done it by buying the site at the right price. So I don't see the black and white case for it's going to knock this amount of money off my house or it's going to increase it by this much, because I've never, the stuff that I've done as an architect, the buildings that we've, the buildings that we've worked with, we've always landed them in a good position where they've made a ton of money at the end of it. So I don't know the answer because I've never really been in the situation where someone's lost money by buying a heritage building, but those weren't my clients. So I don't know the answer.
And as you say, we're in a position where you have people who are sitting in buildings that are now being listed for the first time. So they're the ones, if there is a hit to be taken, they're the ones who are taking it. If they resell, they will resell at a loss, or so they assert. So there's not much option of turning a profit on the deal.
No, they bought their property for what they bought it at. But I do think that for the houses, so not the commercial property, but for the houses, what they sell their house for will also depend on how attractive it is to the market, and part of how it is attractive to the market is how well maintained it is and in what condition it is. And so I don't know if the heritage listing can be taken without the context of the presentation that you would be able to do to put that place on the market. I just don't know where the actual evidence is that says X dollars or X percent or this much is, because I think there are a lot of factors that when they took their property to market would be quite different.
Mr. McCutcheon, from a planning perspective, I say this is at the heart of the Section 32 analysis.
Yeah, and I'm not going to put a number on it, but what I'm going to refer to is the purpose of the Act and whether listing a property contributes to achieving the sustainable management purpose of the RMA. And I also don't think it can be divorced from what the provisions are trying to enable and allow people to do. So the provisions are set out to try and permit people to undertake works that keep buildings in good conditions and not put any barrier in the way of that, or for any other person who wants to do the same activity. And they also, as recommended, set out an enabling framework for greater intensification on these sites where heritage values are not detracted from new buildings. They allow for subdivision under an enabling RD activity framework. So I think that should be part of your consideration in weighing up such a decision.
Mr. Wellington, what do you reckon is the legal position?
I don't think there's a number, because the number depends on the extent to which the policy 21 criteria are met and to what strength they are met. So if you have an outstanding example, an outstanding and almost unique example of a particular architectural form or a building that carries heritage value because of its former inhabitants and other links to heritage, it might be that the number that you can live with, the private impact can be quite strong, could be quite a high number, and you would still list it as a heritage building because it is such a superb example that the cost benefit analysis justifies that. Equally, it may be that even a relatively small number carries the day, because while it meets one or more of the criteria, it's not a particularly strong example, or it has a, you know, the values that it reflects are already more than adequately provided for in the existing heritage listings in the city. If it was to be lost, it wouldn't be a great loss. So I don't think that it's a matter that you can say 10% is fine, 20% is fine, but as soon as you hit 27% of the property's value being lost, then that's it, because it depends on all of those matters being weighed up in the round.
And that might be an answer to the question that Mr. McMahon put. Well, why don't you just find one policy 21 criterion that's met? Yes, met. Tick the box, move on.
That's right. And that answer that I've just given is actually reflected in what Mr. McCutcheon has recommended for the Keir and Cutton site, which is that when you come to approach that question, you might like to have considered the other house whose name I've forgotten. There's another property of similar vintage and I think same architect, which you might like to consider first. And if you're listing that one, then that might affect the approach you take to the Keir and Cutton house.
The owner of which is vociferously objecting to listing as well.
Different house of the Dobson houses. And
the Dobson one, yes, yeah, that's right. Yeah, I remember you saying that.
And that owner, I understand anyway, is not objecting.
Yes.
They nominated it themselves.
Now it's 5 o'clock, people. I'm keen to make a little bit more progress soon.
Me turning into
Just a little bit more
Yes.
on the general things. Do you want to sort of dig into
Yeah, let's start. Further along, so let's get on.
one more thing about public access and visibility. Ms. Cutton and Dr. Keir have actually made the point that access is implicit in the definition of historic heritage in the RMA, and you were saying that you can't see where that is written down. Besides the fact if it's written there or not, from a heritage perspective, do you believe that heritage and heritage buildings need to be seen to have a heritage value, or where is the difference between character building, which I think has to be seen to be adding to the character, versus a heritage building that is scheduled for different reasons?
Yeah, I think you've made a really good point about character and heritage. And I also think that if you look at the regional policy statement, again, that direction is that you only need to meet one of the heritage criterion, one of the heritage criterion, you only have to meet one of them to be eligible to be listed in the district plan, and the criterion that deal with the things that you can see in terms of townscape value and in terms of townscape value, that's just one of all of the things that you're assessing a place against. So I don't think that it's necessary for a place to be visible, say from the street, for it to be a heritage place. But the first question is, how did we find out about it in the first place? Because we have to become aware of these places, and the places that we see every day, we're more likely to be aware of them. So I think that the stuff that we have on our list now is a product of that idea that heritage was pretty and part of our townscape. And I think that as time has gone on, the way that we look for heritage is much more subtle and much more considered. And so we now have places like the goldfields, the Albion Goldfields, which is definitely in the middle of somebody's farm. It's only accessible by tour. It's only accessible if the farm owners want you on their land, but they're incredibly proud of that place. And it's definitely a heritage place as far as I can consider. So,
Putting it another way, do you think there is an inherent bias for those that are visible, precisely because you do know they're there, and you necessarily find out about things that are not visible from other means? Not a bias in terms of an intentional thing, but the way it in practice it pans out.
I think you're right, and I think there's a what there's known in heritage. In the heritage world, there's something called a drive-by listing, which is the kind of thing you spot from your car. So rather than a drive-by shooting, you have a drive-by listing.
Could only happen in America.
No, it was in England.
You clearly need an AK-47 in the back seat to do it properly.
Yeah. So yes, I think you're absolutely right. There is a bias on our lists that, on our historic lists that we've had for the past 20 odd years on things that we can see from the street. And they're a part of our lists, and they're an important thing that people value.
Anybody for anything else before we go to the individual?
Keep going.
Yep. All right. Now, generally, it comes up in many of the individual assessments that you have done and your response to them. You are saying, yes, I can see that there is value. I can see that there has research been done by people. The submitters have actually provided, in cases, whole reports on things. But I need to do more research to be able to assess it.
Yes.
Going back to that idea that only one single thing needs to put it over the threshold to be eligible to be scheduled, how much more research do you think is required to get there?
Hopefully I've answered that in terms of the individual points raised. If not, I'm happy to speak to that as we approach them. I mean,
Okay.
Yeah.
Then let's start with Our Lady Star of the Sea. You have got the Heritage New Zealand report. You have had your own heritage report, and you have visited the site. You have a summary in your paragraph 149. And this is enough for you to include or change it in the
It's to retain it.
or retain it in the plan. The question is, you're saying at 144, Although I generally agree with the research and assessment, I consider that further research and assessment is required for the place to be entered as a heritage area in Schedule 3. Now, what is that extra that we need?
So the site includes a old school that became a convent, or an old school and convent, and it includes a staircase and it includes a chapel, and those things we know a lot about. The site also has a number of houses that that neither the Heritage New Zealand report or the council report includes, and it involves the structures that are associated with the place when it was a school. So there's a swimming pool, there's some buildings around the back, and there's another convent building from the 1950s that isn't enough information in the Heritage New Zealand report or the Wellington City Council report for us to be able to speak to those, I thought. And the point of this assessment was that Heritage New Zealand have identified this as a heritage area, and they've identified the chapel as a heritage building, and their heritage area involves information on 3 of those buildings: the chapel, the staircase, and the old school. But again, it doesn't involve those other things on that site. And so my view was, yes, Heritage New Zealand has a historic area, so we had this place assessed as a heritage area, but actually I think that it makes sense just to include the things that Heritage New Zealand thought were important by putting them in as part of the heritage building listing in Schedule 1. Does that clarify it?
That does clarify that. What it doesn't clarify is that when you have heritage areas, and that's a little bit outside of that, if you have heritage areas, you are not assessing every single building of its values, do you?
No, but in these circumstances, I'd actually have to be able to get onto the site to even see the things. I don't have a photograph. I don't have a book. I don't have any. I don't know anything about any of these buildings. I can't get to them. Whereas in a heritage area, I could stand in the street. If it was a row of houses, I could stand in the street and I could get all the records to things. I can't even see these other items.
And the heritage area that Heritage New Zealand has actually formed.
Yeah.
That's not enough information for you to say if they are happy with a heritage area there. We certainly are happy too, because they must have based their assessment on something.
Yes,
So they will have been there most likely, hopefully.
It's one of the older listings. So if it was a new listing, like if it was a new listing report, yes, but it's one of the old listing reports, and it doesn't have much. It didn't have as much information in it on those additional items. Okay. I thought.
Where do you define old and new? What's the timeline there?
I'm going to have to open the document so I can see.
Just in general, what's the date where you would consider a heritage listing of Heritage New Zealand as old, and where is the cut-off date where you think that's new? Is that 2013? Is that 1995?
So in about 2012, they were going through their defective listings process where they were rechecking the listings that they couldn't find their records for. So anything before then, I would be looking at the report to see if it had the information that I wanted. And the very old listings are the ones from the 1980s where you only have 1 or 2 paragraphs about a place. And I'm not really sure where this building fits.
Yeah, that's fine. So if I understand you right, so in 2012, Heritage New Zealand have gone through figuring out where they have enough information for the scheduling that they have on their list.
Yeah.
Have they taken off the ones that they didn't have information for?
Correct, yeah. So this is what I'd call an old listing. It's from 1981, the original report.
But then, if I understand you right, in 2012, Heritage New Zealand has actually found enough information on that particular site so they could actually keep it in the listing.
Yeah, and so they have updated listings reports for those. So I just need to check whether this is one of the ones where they've written an updated listing report. The key issue is whether it had gone through a council meeting or not, and whether they had the council meeting records or not, rather than the amount of information they had on each place. So the places where they didn't have a council listing, where they'd recorded the council listing of their board listing, of their board agreement to that thing being listed, they had to go back and reassess. So there was a moment when a whole lot of things were parked and then reassessed and then relisted. So it just might take me a moment to find whether there's an upgrade report or
it's more a general question. It's not necessarily just that building, because that comes up in a number of individual buildings. My question is just if in 2012 the list of agency was actually updated and everything on there has now a background in having enough information there and the rest was culled, I can't quite see why you have to go then through it again and see if they have done a good job in 2012.
So this one does have an upgrade report. It's 10 pages long. I can't tell you what the date is because I haven't quite found it. Like I said, it does. We could put this forward as a heritage area, but there would be a number of buildings on that number of buildings and structures on that site that we had no information on.
We'd need to have some confidence whether they would be contributing or non-heritage buildings for the purpose of the rules.
And those buildings are, that there's no information at all on these buildings in the Heritage New Zealand, but they have still included them in the heritage area.
It's because it's an upgrade report. So they did the initial listing in 1981, and their listing in 1981 named these 3 buildings. If they'd actually come and done the upgrade report as a whole new listing, they would have approached us in quite a different way. But I think we're dealing with an old listing, old information, upgrade report, only upgraded on the things that they listed in 1981. And that's all the information we've got. If they'd done a great report, we would have put the whole thing forward.
I might just add, when there's no implications for private property owners by identifying something as heritage within a Heritage New Zealand listing, they might be more inclined to do so than when rules in the district plan kick in.
Right. Anything for that particular one?
No.
Then we are moving on to item 181, state insurance building.
What paragraph is that on?
4.2.
That's from
Page
4.4 Page 38, yeah. From 153 on. What questions do I have? With regards to the schedule entries in your paragraph 159, under E, we are talking about significance or lack thereof. We are talking about some historic and physical architectural values because it was designed by Athfield architects. What are those historical values? I understand they have to do with Athfield architects.
So I just noted my initial view is that there's no evidence to suggest that the addition doesn't have heritage values. And I've just proposed some of the heritage values that I think are possibly there. I can talk, but I haven't actually done the research to back this up. We do have a building on the heritage schedules that is was designed by Athfield Architects, which was the Athfield House. So we do have some information on the significance of Ian Athfield as an architect in Wellington. And in terms of the history of the building, the building has a heritage order, and my understanding is the heritage order comes about because the state insurance wanted to demolish the building. The insurance company wanted to demolish the building. It had already demolished one of its two buildings and that location, and they wanted to demolish the building and rebuild another building on that site. And so this is one of the 1980s heritage orders. So when that didn't happen, they moved out of the building and Te Kukiri moved into it. And the addition on the top of the roof is part of the complexity of that losing its use by state insurance for whom the building had been designed, but also in terms of it becoming a government department building and it being designed specifically to house Te Kukiri. So I think in those circumstances, I do think it is worth considering that the place may actually have significance for those points, but I haven't gone into it in greater depth. I think there's just enough to say you can't say that it doesn't have heritage values. I think there's enough evidence to suggest that it may do, and it probably does.
And you are recommending that it actually stays on the list?
I'm recommending that the addition on the top of the building remains part of the envelope for which the heritage rules apply, so that it's not excluded from it's not an exclusion. And part of that is that question that you had before, which was how do you, if somebody wants to put something different on that space, how do you actually protect the values of the building underneath it? And that was also my concern, and I think we shared that concern.
So in fact, it is a partial scheduling with a new element that is not excluded.
No, it's a building that's scheduled in its entirety listed in its entirety by Heritage New Zealand and scheduled in its entirety by the Wellington City Council, and then scheduled in its entirety within a council heritage area. And I think scheduled and listed in its entirety in a Heritage New Zealand historic area. So there's 4 layers of recognition. Yeah.
Understand that now. Anybody else? Item 299, 4.3, Gordon Wilson Flats. Now the Gordon Wilson flats, I just need to find where the we might actually come back to that later on when we are looking at
The McLean
the McLean flats, yeah. Because I don't think there's a lot of questioning about the Gordon Wilson. I think it's more the combination of the two. 4.4 Johnsonville Masonic Hall. Now, the Masonic community says this thing has no value to us because we want something else. We need something else. We can't work with what we have. But the council says there is heritage value in its link with the Masonic society. Explain to me.
The Masonic, I can't quite remember how they refer to themselves, but the Masonic Lodge community is a shrinking one. And the members of the Masonic Lodge are the men in that community. And so there are a number of people who are associated with the families and people whose families have been associated with Masons, but may not actually be Masons themselves. And my family are associated with Masons because of a connection with a particular industry in the UK. But none of us are Masons. So, you know, there is a much wider community that is connected with the Masonic lodges than is the actual literal members. And some of, you know, the members are an aging community, and some of the losses are through age as well. So I think when we look at the Masonic community, we look at the number of people who are lodge members, and we look at their families and the wider connection to that. I think we also look at the value that the Masonic community has provided for New Zealand, and it has done a lot of things in terms of you know, in terms of its charitable works, in terms of its looking after its communities and looking after the kind of wives and widows, and in kind of healthcare, its interest in looking after children and providing scholarships and sponsorships and charitable work. So I think, yes, there is a group of a couple of hundred people who are literally connected to that site, and there's a much wider community that are connected to the lodges in the same way that the church community is shrinking, and the bowling club communities are shrinking as well. You know, so I do still think there is a community association, and I do still think there's an identifiable community that this place is associated to. But I do agree that as the community, as they leave this building, and as the lodge system shrinks further, then there will be a loss of that connection over time. But I think at this moment in time, we do still have this connection with this place to more than the people who are literally a member of that place. And I think that's one of the reasons why our thematic heritage study looks at things like Masonic lodges, fraternal societies, Manchester Unity, the kind of the mutual assistance groups that developed in the pre-welfare state of New Zealand.
Thank you for that.
Wonder if we could call a halt for the evening. It's 5:30.
Yep.
Thank you very much, people. We'll adjourn until we return 9 o'clock tomorrow morning. Yeah.
Between alcohol is involved. Not do that. Right, we can leave our stuff here, can't we?